Well, hello everyone, and good morning, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in both Virginia and Texas. It is May the 11th of 2023, and we are here with your legal news roundup, all the legal news occurring in your world so that you can be better informed. We begin with our story this morning regarding the college admissions scandal that many famous people got wound up in recently. You'll remember this from about a year ago or so, where there were a bunch of famous people and famous parents who got caught up in this college admission standards scandal, where they basically bribed their way into colleges. Well, some of those parents have actually now had their convictions overturned by an appeals court. So an interesting development. The First Circuit Court of Appeals, which deals with the northeast corner of the United States, Maine and such, has tossed convictions against Garland Abdazela and all but one conviction of another parent, John Wilson. So this particular Court of Appeals has taken a look and said, hey, as to these charges, as to these people, these are not valid convictions. So let's learn a little bit more about what happened and why the First Circuit reached this conclusion. Let's get started with this. The First Circuit Court of Appeals overturned all the fraud convictions Wednesday of two parents who were found guilty of paying bribes to get their kids into universities as part of that college admissions scandal that was in the news a year ago or so. The First Circuit Court of Appeals tossed all the convictions against Gamal Abdazaleza and all but one conviction of another parent, John Wilson. The Boston-based appeal court upheld Wilson's conviction on charge of falsifying a false tax return. So lying to the government about the money and how much money they had, but not really directly related to the college admissions issue. The jury in Boston had found the pair guilty in 2021 of buying their kids' way into school as athletic recruits in a first case to go to trial in what was then called the Operation Varsity Blues investigation, which is a great name. The FBI sometimes comes up with these great names for these investigations, and they called it Operation Varsity Blues, which is kind of cool. So anyways, they were part of that investigation scandal that, of course, infected many schools all across the country, nationwide. The woman Abdazales, who is of Las Vegas, was accused of paying $300,000 to get her daughter into the University of Southern California as a basketball recruit, even though they didn't even make it onto the high school's team. So that is basically the deal, right? $300,000 bribe. You say that she's an athletic scholarship, but she has no athletic skill. So it's just a bribe to get you into school. So yeah. The authorities had charged Wilson, a former executive at Staples, having paid $220,000 to have his son designated at University of Southern California as a water polo sports scholarship, and in addition, $1 million to buy his twin daughter's way into Harvard and Stanford. So this affected a lot of different schools in a lot of different places with a lot of different things, but this was basically the scheme for a lot of them. Athletic scholarships was a major way that a lot of these scams worked, right? We give you money, you pretend they're an athletic scholar, they get into school. How much money are we spending? Hundreds of thousands to low millions of dollars each for the bribes. So, pretty serious stuff. The lawyers for the individuals who had been convicted argued their clients believed they were making legitimate donations, and an admissions consultant at the center of the scandal, William Singer, pitched his so-called side door scheme as a lawful one. So yeah, this gets into interesting domains of these issues, right? When is it lawful and when is it not lawful to do this kind of thing? And that's a good question, because people do give donations to universities. And sometimes there is an expectation, sometimes unspoken, sometimes perhaps a little bit more spoken. But there is sometimes an expectation that, that new wing at the library comes with some sort of quid pro quo. And if that's spoken or not, but there might be an understanding. So the question becomes, okay, when is this legal? When is this not legal? When can you give money to a university for the admissions scholarships or admissions period? To what extent can the college take money for admission? So the idea that this might be legitimate is not, in the first instance, inherently absurd, because, of course, some of this might be legitimate in a different form. Now, of course, the details are where often things get tricky, because very often the same act can be both legal and illegal, and a lot gets into a person's knowledge of things or their intent behind things. That's the mens rea element of the thing, right? So we don't require people to know the law, but we do require people to have a guilty mind, so that they have, in some sense, a knowledge or intent to do a nefarious thing. So a lot comes down to legal liability of a person's knowledge or intent of their own wrongdoing. And so if a person really doesn't think that they're doing anything wrong, they really believe that, and there's no reason to believe it objectively, then that might not be criminal. So that's the kind of thing we're talking about. The 3-judge panel of the First Circuit said the trial judge was wrong in instructing the jury that an admission slot constituted property of the university under mail and wire fraud law. So one of the issuing things is, in fraud, right? Fraud is I'd lie to you to induce you to do a thing, right? That's fraud, right? I lie to induce. In the particular case of wire fraud, it requires the lie to induce to be in exchange for property, which often makes sense, right? I'm inducing you to give me money. That would be a typical fraud, right? I am lying to you about whatever in order to induce you to give me money under a false pretense. But of course, it doesn't have to be money. It could be some other kind of property, right? Fraud for land, fraud for a house, fraud for a car, fraud for some sort of property. So one of the questions legally is this admissions space at the university property? And the First Circuit says, no, it is not legally property in this sense. So you can sort of understand where that idea comes from, because it is somewhat distinct from the idea of a car or other sort of tangible or even intangible thing, because there's not necessarily a limit. A university can admit as many people as it wants. And it's not really property in that sense, because it can't be really, the slot can't really be given to another university. It can't be alienated from the university, right? If I own a car, I can give you my car. I no longer have the car, you have the car, right? So I have alienated that property from me. But a university can't really do that. One university can't give its admission slot to another university, so now they have an extra space. So the idea that that's property or not sort of makes sense. So that's probably one of the rationales behind it. The judge found the government also failed to prove the parents agreed to join the conspiracy, because conspiracy, of course, requires intent to join. A conspiracy by its nature is an agreement to do an illegal thing, and then an illegal thing occurs. But if you don't have an agreement to do an illegal thing, you don't have a conspiracy. You have to have agreement. And if they didn't realize they were agreeing to an illegal thing, it's not conspiracy. You have to have some idea that what you're doing is illegal. So yeah, that makes sense too. The court noted that the government was allowed to introduce significant amounts of powerful evidence related to other parents' wrongdoing in which these defendants played in no part, creating an unacceptable risk that the jury convicted based on others' conduct. So yeah, that's obviously a problem, right? If you're part of a conspiracy, then you can introduce evidence of other people in the conspiracy, because you're part of a conspiracy and you're along for the ride. Conspiracy doesn't necessarily require that you know what other people in the conspiracy are doing, or even that there are other members of the conspiracy. This is one of the downsides of joining conspiracies, people. You don't want to join conspiracies, because if I join in a criminal conspiracy with you, and then you independently, and not to my knowledge, extend the conspiracy to another person. Guess what? Suddenly now I'm in a conspiracy with that other person. I don't even know they exist. But now they're part of the conspiracy because you, my confederate, brought them into the conspiracy. As my partner in the conspiracy, I am responsible for the things that other partners in the conspiracy do, including adding other partners. And I don't necessarily know that they exist or even know what they are doing or their criminal actions. But if I'm part of the conspiracy, well, sucks to be me. So don't join conspiracies and you won't run into this problem. But if they are not part of the conspiracy at all, if they're not part of this conspiracy, and we're bringing in evidence of other people's wrongdoings, well, now suddenly that's a real problem. Because Jack broke the law doesn't mean I broke the law. If we're not part of a common device, a common plan, a common agreement, if I'm not an accessory, I'm not a conspirator, it's like, okay, well, we both independently broke the law. Maybe. What does one thing have to do with the other? Nothing. So to the extent that you're doing that, that's a real problem. The ruling, of course, is a blow for prosecutors who netted 50 convictions in the scandal, presumably because, of course, this decision would potentially impact other decisions in other circuits with respect to other people, depending on the specificity of what exactly happened. So depending on the details, of course, and depending on how other circuits look at it, of course. But, one court of appeals has looked at this and said, okay, not so much for the wire fraud. So, of course, everyone else is saying, hey, wait a second, maybe not so much for the wire fraud, me too. Maybe I'm also not guilty of the wire fraud or other things. So, of course, this has some potential ripple-on effects depending on the details. This, of course, went from various colleges, including Yale, Stanford, Georgetown, University of California, Los Angeles, and many other schools. Some of which are not necessarily elite schools, incidentally. So the bribes were a little bit strange because they weren't necessarily that selective. Some of these schools, obviously, extremely selective. Other schools, part of the scandal, not so much, which made you wonder why they were doing it, but whatever. The attorney for the United States government says they're reviewing the opinion and next steps. Your next steps include asking the First Circuit for an en banc or asking the U.S. Supreme Court for review, either of which is difficult. Also trying to prevent spill-on effects into other circuits, So yeah, but they're looking into it. The attorneys for the people who had previously been convicted emailed a statement saying that their clients have maintained absolute innocence and they're enormously grateful. I bet they are. We're pleased to have represented our clients and look forward to putting this behind them. Yeah, okay, so, good for you guys, I guess. Thus, that brings us to the end of the discussion for the moment of this latest update in the college admission scandal from a couple years ago. There were a bunch of people who got caught up in the scandal with 50 convictions for various parents who bribed their way into colleges, often by convincing the college one way or another to create an athletic scholarship for their kid who had absolutely no athletic skill of any kind. So just money for admission. And this could have been fraud, but maybe not, because, well, under the relevant statute, an admission space may not be property, which makes logical sense if you think about it. Doesn't really have the sort of things that property do. You can't really alienate it. You can't really destroy it. It's not really limited. So yeah, it's not really property in a conventional sense. And also that they weren't part of the conspiracy because, well, they didn't necessarily know that they were doing something illegal or have any clue that what they were doing was illegal. They didn't have the necessary mental state of knowledge or intent, for example, to join in a conspiracy. So if what you really think you're doing is just, doing what is legal, then that goes a long way to your mental state as a matter of fact rather than a matter of law. So yeah, they look at this and like, okay, well, those things. And obviously, this will impact cases beyond these people because suddenly 50 other convictions have suddenly, maybe those other convictions also have similar problems. But of course, maybe not, because it would depend, of course, on the specific details. But you can bet your bet that a lot of other lawyers are taking a second look at those convictions and looking at the details right about now. But that, for the moment, brings us to the end of discussion of this case. All right, good morning, everyone. Welcome to Uncivil Law. I love you, chat. You are the greatest chat. I love you all. Thank you so much for being here today. You guys are awesome. I love you all very, very much. We are here, of course, also with 5 new opinions from the U.S. Supreme Court that just happened just now, because the Supreme Court announces opinions at 10 o'clock on days when they announce opinions. And obviously it's now 10:36 on the Eastern Coast. And we have 5 new opinions from the U.S. Supreme Court. Brand new law that just happened right before our eyes. So of course, being a good legal review channel, we're going to cover all of them today. Because, that's how we roll over here. We need to know law. Some days it's a little bit more, of course, true crime heavy, or we're just learning about someone who did a bad thing in various ways. So some days we get a little bit more true crime heavy, but some days we get a little bit more legal analysis. Of course, it depends on the roll of the dice. Today we got all of our Christmases, right? We got five, count them, new legal opinions from the U.S. Supreme Court. The law has moved, people. The law has moved. What is lawful law? What lawful law is changed in the last 30 minutes? So we have to cover it. All right, just as a friendly reminder for tomorrow, we are planning on doing a gaming stream tomorrow. The new Legend of Zelda comes out, Tears of the Kingdom. We will be playing it. Also doing Verdict Watch for Lori Vallow, which is a very strange combination of things to be doing. So we'll be doing Verdict Watch and watching someone get convicted of murder while Link runs around the plains of Hyrule and, solves dungeons or something. I don't know, but this is how we're rolling. So we're doing that. Good times. All right. Let's discuss some new Supreme Court stuff. Oh, and just a friendly reminder, of course, to the 200 of you who are here, if you'd be so kind as to please share this on your social media of choice. There should be a share button below your screen somewhere. If you could tweet this or retweet this or share it on the Facebook or text a friend or I don't know, whatever, that would help. That would help a lot. That'd be great. Please do that. Thanks. All right, great. Moving on. For our coverage today of the United States Supreme Court, we turn our attention to an illegal immigrant who is facing deportation and interested in, perhaps not being deported so much. And we are going to cover the law as it relates to this. This is the case of Santos-Zacaria versus Merrick Garland, in which we cover this deportation proceeding and the laws it relates to deportation, a topic that's always of interest in the United States. Let's learn a little bit more about how deportation works in the United States. The petitioner, who goes by the name of Estrella, is a non-citizen in removal. In other words, they're an illegal immigrant, and we'd like to kick them out of the country. Those are what those words mean. Non-citizen, illegal immigrant, removal. We'd like to deport them. Okay. She sought protection from the deportation, which an immigration judge said no. No, you we're deporting you. She appealed to the Board of Immigration Appeals, which said no, we're going to deport you. She then filed a petition for review in the Fifth Circuit, alleging the board had impermissibly engaged in fact-finding that only the judge could do. So this is a division question as to what different courts do. So trial courts do fact. Courts of appeal do law, okay? You don't bring new facts into appeal, all right? Your ability to bring new facts into appeal are extremely limited, okay? To the point of almost non-existence. If you want to fight over facts, you do it at trial. If you want to fight over law, you do it on appeal. That's what that's for. So this person says, okay, the problem is that the appellate board in the immigration did fact-finding. They did what a trial does, and that's not what they're supposed to do. They're not supposed to do facts. They're supposed to do law, but they did facts in a way that's improper, okay? That's what she's alleging. The law that's on issue says, the Fifth Circuit said, rather, that she had not satisfied her exhaustion requirements. So the Fifth Circuit says, we're not going to hear your appeal at this time because you need to do administrative remedies first. The board is an administrative board. Okay, they're an appellate board, but they're administrative. So your complaint is administrative in nature because the administration did it bad. The first thing you have to do is ask them for relief. You have to exhaust your administrative remedies, and you didn't do that. So the Fifth Circuit says, go away, ask them for relief, and then maybe come back. All right, the relevant law provides that a court, such as the Fifth Circuit, for example, may review a final order of deportation only if the alien, the illegal immigrant, has exhausted all administrative remedies. So, as is typical in federal law, you can't go to court until you exhaust all administrative remedies. This is not necessarily true in state law, but it is in federal law. If you want something, you got to ask the administration first, because the idea, of course, being if they give you what you want, then there's no reason for a court to get involved. And administrative agencies have different levels of review internally, so they have their own internal appeal processes. So you got to go do that first. And so the relevant law says, go do the administrative appeals, which is pretty typical in federal law. The Fifth Circuit raised this issue on its own. So the Fifth Circuit said, okay, you failed to do the administrative remedies, but that wasn't an argument that anyone asked the court to do. They just brought it up themselves. They said, okay, you can't do this because you need to do exhaustive remedies. And we're deciding that even though no one asked us that question, we're just telling you. All right. They made that decision on the basis that the exhaustion requirement was jurisdictional in its nature. So that would be a proper thing for a court to review. It's a question of subject matter jurisdiction, okay? Which incidentally is one, if not the only issue I know of that you can raise at any time, at any level of appeal, no matter what, right? We normally cover the concept of appeals, of you use it or you lose it, right? We normally cover this concept of you either object at the time and you preserve your objections or you can't raise it again. We have often covered cases on appeal where someone's like, hey, a mistake happened below. And the court is like, did you tell the court below about it? And they're like, nah. And the appeal court's like, we're not going to consider it. You have to bring it up and preserve your issues. If you don't, they go away forever, right? But subject matter jurisdiction is probably the only issue that's not like that. It is the exception because subject matter jurisdiction goes fundamentally to the power of the court to hear the issue, period. Which of course would be also true of the Court of Appeals, incidentally, or the Supreme Court, because if they don't have power, then obviously they don't have power. So you can raise it anytime, at any level, even if you never brought it up before. It's unique in that respect. And also courts are required to consider subject matter jurisdiction on their own. So the Fifth Circuit saying we don't have subject matter jurisdiction is a thing courts are supposed to do. They're supposed to do that. It's like, if we don't have subject matter, we can't do it. The fact that no one brought it up, we have to bring it up ourselves. And incidentally, this has actually happened before at the US Supreme Court as well. It has actually happened before where the US Supreme Court themselves, sua sponte, on their own initiative, brought up the issue of subject matter jurisdiction, which hadn't been raised at any level of appeal at any time. They just said, hey, although no one brought it up ever, we don't have jurisdiction. In fact, the Court of Appeals didn't have jurisdiction, and the trial court didn't have jurisdiction, so this whole case never happened at all. The entire case just goes poof, completely, because the courts never had power. So that's what the Fifth Circuit is doing. Okay, so they're saying this is jurisdictional in nature. And because the Fifth Circuit concluded that this individual had failed to exhaust it, then we literally don't have power to hear the case. We have no power. All right, so that's the issue. All right, is this a jurisdictional requirement? Is the issue jurisdictional in its nature? Is the fact that they failed to exhaust administrative remedies a question of jurisdiction? If it is, then that raises a whole new level of problems. If not, less problems. So which way does that go? The Supreme Court says in this particular instance, the exhaustion requirement is not jurisdictional in its nature. So it's not a subject matter jurisdiction problem. So you made the wrong conclusion, Fifth Circuit. It's not that you didn't have power, period. Maybe something else, but not this. All right. Jurisdictional prescriptions set the bounds of a court's adjudication authority, while non-jurisdiction rules govern how courts operate within those bounds. So one issue is, where are the boundary lines? The other issue is, what do you do when you're inside those boundary lines? So if you think about this like a piece of property, right? A piece of land, question number one would be like, where are the boundaries of your land? That would be a really good thing to know. Question number two, once you define the boundaries of your land, what are you allowed to do within them? Like, what can you mine? Can you build a house? Can you build a factory? What are you allowed to do on your land? But where your land is, obviously kind of more important. So that's the difference. Where's your land versus what can you do? The jurisdictional tag carries potentially harsh consequences, yes, because if it's not within your boundaries, obviously you have no power of any description. What are you allowed to build on your non-land? What are you allowed to build on your non-property? This question doesn't make any sense. It doesn't make any sense for the courts either. So if it's jurisdictional, it's like you're asking fundamentally dumb questions. So yes, it can carry pretty harsh consequences. And as the Supreme Court notes, and quite properly, courts must enforce these boundary line problems sua sponte. They sure do. They must do this. So if it's boundary line, yes. Even if that, of course, forces a litigant's forfeiture or waiver. So yes, this can be quite harsh. Because if the court doesn't have power, then a litigant might get really, really screwed. But if the courts don't have power, they don't have power. So this can be pretty harsh. To ensure courts impose these consequences only when Congress has done so, we say it's jurisdictional only if Congress makes it clear it's jurisdictional. So we try to avoid this particular harsh consequence because it can lead to nasty problems. The relevant law lacks a clear statement that this is jurisdictional in its nature. First, exhaustion requirements are quintessentially a claim processing rule designed to promote efficiency. So it's more how to go about it than what you can do. This is more how than what. Treating the exhaustion requirement as jurisdictional, like what, would disserve that interest. Secondly, the language differs substantially from more clearly jurisdictional language in related statutory provisions. So of course, some statutes are jurisdictional. The idea that this is like inherently absurd is not right. This is something that Congress does do often. So they are, simply saying that it wasn't what Congress did here. Congress sometimes say that no courts should have jurisdiction to review certain matters, which they can do because different courts hear different kinds of things. And certain subjects go to certain courts. And sometimes Congress wants appeals to be done this way, and sometimes they want to be done that way, and sometimes this court, sometimes that court. So yeah, that's pretty frequently. Taken together, these two features that we see in other statutes but not present here says that this is not jurisdictional. Given this standard that we need to be clear because it's really harsh if we do it, so we're going to avoid it if we can. So given the we want to be clear standard, the government offers no persuasive reason why we should depart from that here. So the government isn't saying, oh, it's really clear. Somehow you're idiots, you're misreading it. No, they're saying, no, it's implied somehow. And the Supreme Court says, okay, that's not good enough. And the government says, okay, well, it should be good enough here for these reasons, right? You should make an exception. This should be jurisdictional. And the Supreme Court's like, no. So merely that a statute addresses a court and describes review does not necessarily mean that that's jurisdictional. Yeah, no. Secondly, the government fails to show the law clearly carries forward any understanding that a prior version was jurisdictional. So, assuming that some prior version of this statute was jurisdictional in its nature, Congress changed the law in a way that no longer makes it clear, which kind of suggests inherently, by the way, that Congress didn't want it to be jurisdictional, because normally when Congress changes language, they want to change it from something to something else, right? So if Congress, assuming the prior version of the language was jurisdictional, and they dropped the language, it would be a bit of a strange conclusion to conclude that Congress really wanted this new version to be jurisdictional. Because otherwise, why did they amend it out? So that would be a strange conclusion to draw. And no, we're not going to do that because that would be dumb. Finally, the placement within the statute is insufficient to say that it's jurisdictional. The relevant law does not require non-citizens to request discretionary forms of review like reconsideration. So you do not have to do that. The relevant law doesn't require you to seek reconsideration. If it did, then, fine, but it doesn't. So the decision from the board was final. You could have asked for further review, but you don't have to. It'd be like asking a court of appeals for en banc before going to the Supreme Court. You don't have to. The decision from the Court of Appeals is final. You can ask them for further review, but you don't have to. Reconsideration of the board, of course, is discretionary, much like an en banc review from a Court of Appeals would be. Board reconsideration is therefore not available as a member of right. Therefore, it can't be required to pursue it. Fair enough. The government cannot show that exhausting remedies available as a right requires the board seeking reconsideration. The government emphasizes that the non-citizen's right to file a motion to reconsider, but right to request discretionary review does not make that a right. You have the right to ask, but not the right to get it. Nor does the relevant law draw a distinction suggested by the government between those remedies made discretionary by statute and those of regulation. Which also would be kind of strange. If a statute says, yeah, you can do this, or a regulation says, yeah, you can do this, either way, it's saying, yeah, you can do this. Why would one be mandatory and one not? That doesn't really make sense. In addition, although the decision as whether grant review is reviewable for abuse of discretion, it's still discretion. So, it's still optional. If you exercise the option, the court has to grant it under the standard of abuse of discretion. But it's still optional. It would be like me going to, get a driver's license, for example. Nothing requires me to get a driver's license. I cannot get a driver's license if I want. But if I decide to go apply for a driver's license, the government has to, decide to do that or not with standards in mind. And if they say no, then there's a way to review it. But that doesn't, in the first instance, make it not optional. It is optional. If I exercise the option, the government, is bound by rules, but still optional. Yeah. Non-citizens would need to seek reconsideration in every case if this was mandatory, but it's not. Yet the statute is designed around pursuing judicial review. So if we said this was mandatory, everyone would have to do it. And if we did that, then obviously there would have to be a lot more requests, and that would be bad because that would put a burden on the board. So that would also be dumb. And the courts would be flooded with pre-consideration petitions for review. So it would also put a burden on the courts, which would also be dumb. Alerts to problems with requirements for non-citizens to always seek reconsideration. The government instead says that only sometimes. Oh, okay, so we're going to solve this problem by saying, okay, it's only mandatory some of the time. Yeah. When the non-citizen is raising an issue not previously presented to the agency. But seeking reconsideration does not qualify as a remedy. Because it's not. That's dumb. Instead, it does not qualify at all. The government's approach would not fix the problem of producing pointless, unexhausted petitions and would introduce practical difficulties. Yeah, and the United States Supreme Court is unsurprisingly unanimous because this sounds really, really dumb from the US government. This sounds exceptionally dumb. So, no, none of those things. Thus, that brings us to the end of the discussion of Santos-Zacaria versus Merrick Garland. Santos-Zacaria is an illegal immigrant, and the government would like to deport them. The person who's being deported complains that the Board of Immigration entered in new facts that the immigration judge did not consider in a way that's improper. So they brought in new facts into the appeal, which you're really not supposed to do. And to the extent you can, it's extremely narrow. So they did it bad. The board said go away, but she didn't ask for reconsideration before going to the Fifth Circuit. So the Fifth Circuit said, we can't hear this. And the Supreme Court says, yes, you can. So, yeah. So this will be remanded back to the Fifth Circuit Court of Appeals, which will have to consider the actual legal issue in play. Namely, did the Board of Appeals do a bad? Did they do something they weren't allowed to do? Did they bring in facts in an improper way? Did they screw up? So they actually have to get into the legal issue, which I don't know what the answer to that question is. I don't have a clue, but they would have to actually look at it. So that's what happened, and that brings us to the end of discussion of this case. That turned out to be fun. Hey, Lawn Lumber's here. Hi, Lawn Lumber. Would you like to discuss Supreme Court cases? We're doing a more thorough review today, but if you'd like to, I will send you a link. We've got 4 other Supreme Court cases for your consideration today, Rob. Let me give you a brief preview to see if you'd like to join us on any of them. We've got one that's a complicated split decision nightmare that you could help me untangle, dealing with pork in California. The state of California imposed a law that said pork sold in our state has to come from pigs that are kept in pens of certain sizes. Those sizes are different than federal law. It's Dormant Commerce Clause time, Rob. Can the state of California impose this requirement that's stricter than the federal law when that by its nature would make pork from other states harder to sell in California? Would you like to discuss the nightmare split decision on the Dormant Commerce Clause decision? That would be option number 1. We've got a Puerto Rico case dealing with the board in Puerto Rico and whether or not we can sue them or not with respect to bankruptcy provisions. So can we sue Puerto Rico? So, and it has to deal with bankruptcy. That's kind of your domain. Would you like to discuss whether or not we can sue Puerto Rico with the bankruptcy or whether or not they're immune under federal law? We could discuss that. That'd be good. How about the case of, what is this one? Hold on. What is this bullshit? Okay. Whether or not a private citizen owes the government of the United States a duty of honest services. Can a private citizen be convicted of honest services fraud with respect to their services to the federal government? That's an issue. And then we've got Okay, can you be convicted of wire fraud by withholding information? Yeah. Can you be convicted of wire fraud for withholding information? So it's not that you lied, it's that you withheld stuff. So what do you want a piece of any of that? Push the button. Thank you. He's catching up. The 2x. All right, fine. Let's see if Rob wants a piece of any of that. Hello, I'm back. Sorry. I might have accidentally pressed the mute button. Thank you for telling me. Thank you. So would you like to join me? Let's do the pork one. Let's do the pork split decision Mark's nightmare. Let's do some Mark's analysis and count votes and figure out what the law is in a split decision dormant commerce clause nightmare, Rob. Check? Yeah, there we go. Great. We got it. All right, great. Yeah, we're fine. It's fine. Thank you for letting me know. Not like Natalie the other night when she was muted for like 15 minutes and I'm desperately trying to call and text her while she's streaming. You're muted, Natalie. You're muted. While we're waiting on Rob to decide if he'd like to join us for a stream, give you 15 minutes. Save dormant commerce clause in Puerto Rico. You got it, Rob. All right, I'll send Rob a link. We're going to have guests today. I'll send him a link. All right, I'm sending you a tweet. All right, great. Rob has a link now. All right. Push the button. Push the button. Oh, there it goes. Do I know anything about Alford clauses in plea deals? I mean, a little bit. An Alford plea is just a no contest plea. It's just agreeing that the government has enough evidence against you without you actually admitting to guilt. It's a no contest plea. I mean, I know a little bit about it. All right, let's do something else. Let's see. Turn around, Brianna. Turn around, Brianna. All right, let's discuss this case. Turning our attention to the United States Court of Appeals for the Federal Circuit, which is a court of national jurisdiction but on limited issues, primarily patent law and also claims against the federal government for financial redress. One of the judges has been investigated recently as to whether or not they are still fit to hold office. So there's been some controversy in the Court of Appeals for the Federal Circuit relating to Judge Newman and whether or not she is still competent to be a judge. Well, the judge herself has now sued her own court to stop the investigation. So Judge Newman of the Federal Circuit has now sued the Federal Circuit to stop the investigation of the Federal Circuit into the Federal Circuit judge. So let's learn a little bit more about this controversy as it relates to Judge Pauline Newman. United States Circuit Judge Pauline Newman of the Federal Circuit has filed a lawsuit against the appeals court chief judge and others in Washington federal court. I assume the court of DC, I guess. Who has jurisdiction here? I don't even know. This is weird. Who has jurisdiction to hear this case? This is weird. Anyway, she's trying to sue somebody somewhere. In the complaint, Newman, who is 95, denies there are any legitimate concerns about her mental and physical capacity and claims that the probe into whether or not she has capacity violates her constitutional rights. So that's pretty interesting, of course, right? So it's like, yes, I'm 95, but I'm still as fit as a fiddle, and you have no right to look into me, Chief Judge and other members of the court, which incidentally, like, you know, what are they going to do about it? But, you know, they're lighting, and now she's suing back. So that's fun. Newman, who is, of course, a leading intellectual property law jurist, as pretty much everyone on the federal circuit is, because they are, by law, the only court of appeals that hears all patent cases nationwide. So they are unique, sort of, in that respect. No matter where you come from, if you're in Texas and you're appealing, you're not appealing to the Fifth Circuit like you normally would. If it's a patent law issue, baby, straight to the Court of Appeals for the Federal Circuit. So they were appointed in 1984 as the judge, as the patent law focused Federal Circuit, which, you know, yes, which often hears major cases involving technology companies, because yes, that's what they do. She has served on appellate panels for these years and served on more than most of her colleagues and issued 8 opinions this summer, according to her complaint. She's also said her productivity has not dropped in the last 3 years. So she's still as good as she ever was. The probe into Newman's fitness to hold office was prompted by an order made public last month by the circuit chief judge, Kimberly Moore. So one of the judges on every circuit is designated as the chief judge, which is an administrative role principally. Among other things, they typically are the ones that assign, you know, which judge is on which panel, because panels are 3 judges and the courts of appeal are more than 3 judges. So which judge sits on which panel? That's typically something the chief judge does, and they also do other administrative roles. So the chief judge said, okay, we're looking into whether or not this other judge is fit. A 3-judge committee apparently had determined that Newman might suffer some sort of disability. So I guess we'll call it a panel. Is it still a panel? It's 3 members of the court. 3 members of the court decided that she might have a problem. She refused medical evaluation. The lawsuit claims the orders justifying the probe were riddled with errors, describing an assertion that she was hospitalized after having a heart attack in 2001 is fake. So we're dealing with fake news, people, and disinformation. Judge Newman says that Chief Judge Moore has engaged in some misinformation, disinformation, fake news. So all kinds of fun stuff happening over here. Newman's complaint also says the committee investigating her gave only a few days to comply with requests for mental evaluations and private records, which she called a baseless invasion of privacy. An attorney for Newman said the complaint of course speaks for itself. Representatives from the Washington, D.C. Federal Circuit did not immediately request to comment. Yeah. The Court of Appeals for a Federal Circuit is an interesting one, guys. It is a very interesting place. It is a very kind of elitist kind of thing, because, you know, they're these subject matter experts, and they're an interesting bunch. I have been to the Court of Appeals for the Federal Circuit many times. It's an interesting place to be. The Newman's lawsuit seeks to protect her constitutional rights and reputation As the case unfolds, it remains to be seen whether the investigation will continue and how it will impact her legacy. So, all that good stuff. So fun. Thus, that brings us to the end of the case of Judge Newman, 95 years old, who, depending on who you ask, is either as competent and great as she ever was, having been a member of the Court of Appeal since 1984 and crushing it for the last 40 years, or she's incompetent. Also, by the way, just incidentally, I'd like to kindly remind President Biden that I am actually a patent lawyer, and I'm also already admitted as a lawyer before the Court of Appeals for the Federal Circuit. I'm admitted. And I'd like to, and for 15 years, I've been a patent law professional. So I'd just like to kindly remind President Biden, as he's considering potential replacements for Judge Newman, that I'm fit and young and knowledgeable, and I'm ready to roll, and I'm more than happy to move back to DC to be a member of the Court of Appeals for the Federal Circuit. So if they need somebody, this 15-year patent professional already admitted to the court is more than willing to stand up his call for his country. So give me a call. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye. I've never appeared before Newman, no. No. I have no personal insight. Not a real goodbye? What for? Why is it not a real goodbye? Well, you're criticizing well, it's goodbye for that story. I mean, it's going to be edited up. It's the goodbye for the story, when it gets edited. It needs to have an outro. Critics. All right. Let's do this story. Push the button. Push the button. Push the button. Thank you. All right. In cops versus rap artist news, Jay-Z has defeated a claim from a bunch of police officers that were sad that he sold the music group Tidal in a $300 million deal. The cops were part of a pension fund. The pension fund was invested, apparently, in Tidal. And so the cops were sad because they thought that this sale of this asset wasn't all it could be, and they weren't getting enough money for their pensions. So they sued. Jay-Z has won. He's got 99 problems, but a cop ain't one. Hit me. Jay-Z's $300 million sale of Tidal won a lawsuit against the group of police officers who contested the deal. According to Reuters, the Delaware judge tossed out the class action brought forth by the city of Coral Springs pension plan against Jack Dorsey and other members of the board. The pension fund, a shareholder of Block, formerly known as Square, said the company's purchase of HOV's streaming service in March 2021 seemed by all accounts a terrible business decision. So they're upset that this business decision apparently is not so good, and they are doing that. And yeah, in their complaint, they cited Tidal's struggling revenue and loss of major contracts, as well as involvement in an alleged Norwegian criminal probe regarding streaming numbers. So somehow Norway enters the picture as to whether or not Tidal is being honest about its streaming numbers or not. So, okay. The company has also allegedly accepted a $50 million loan from Jay-Z himself to help shore up the finances. So maybe the company isn't as on sound footing as their books may initially appear. So maybe the books are wrong, or maybe they're not being properly disclosed. Okay. While Mr. Jay-Z wasn't listed as a defendant, his name, of course, frequently appeared in the lawsuit due to his involvement in the sale. And he joined the board of the company the thing was sold to as part of the deal. So Jay-Z, as part of the deal for sale of Tidal, got to join Block. And so maybe, he did it for nefarious personal reasons as opposed to good business reasons. The 53-year-old Jay-Z sold his 87% share in the company for $306 million, but with adjustments came out to $237 million for the 82% stake. So not quite sure how that works, how $306 million actually becomes $237 million, but that's how that works. So $237 million net, I guess, which sounds like a pretty good payday. I mean, I'm not an expert in such things, but if you'd like to write me a check for $237 million, I'd be more than happy to accept. Uncivil Law, the entity Uncivil Law, is available for sale for the low price of $237 million. So if you'd like to buy Uncivil Law, give me a call. The Brooklyn billionaire personally received proceeds in excess of $63 million, which also sounds pretty good. I'll also take $63 million for the sale of Uncivil Law. It's already at a discount. We're a fire sale. We were initially offering at $237, but now it's only $63 million. How can you resist this deal? Everything must go. Despite scoring a victory regarding this, the legal issues may not be over, as Roc Nation was recently accused of stealing a single for various other people. So, again, with like copyright infringement or plagiarism or ID theft or whatever, more lawsuits in the music industry about who owns what song, blah, 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 blah. According to All Hip Hop, Houston-based music producer Kerry Brown, the managing member of Crucial Productions, Crucial, spelled with a K, accused Jiggy's company of using copyrighted beats. Yeah, we're just doing Ed Sheeran all over again. That's fine. Yes, we own those beats. No one else can own those beats. We like beats. We like beats on our salad. The beats are good. The allegations invoke ASAP Ferg's Plain Jane, which was released in 2017, and Gorillaz' breakout hit FNF Let's Go from 2022. Per the lawsuit, Brown claims that he met Roc Nation's vice president, Lenny Santiago, better known as Lenny S., at the Deals Makers Conference in Houston in 2015, where apparently he was given samples of instrumentals with an eye to build a relationship, but never transferred the rights to the music. So apparently they had a run-in at some sort of conference somewhere, and we're handing out mixtapes, guys. We're still handing out mixtapes, old school. We're handing out mixtapes at conferences, like, here's some beats. And apparently, that the beats were used in a way, and copyright infringement and blah, 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 blah. Brown said he found 2 instrumentals, You Don't Know Nothing About Me, and audio box instrumentals were used for Plain Jane and FNF without permission. Roc Nation, Lenny Santiago, Sony Music, and Block Noise Recordings have all been named in this lawsuit relating to the copyright issues on this mixtape handed out at a conference and the illegal appropriation of the beats, man. The beats. The only song I know by the Beats was called Killer Tofu. Brown claims that neither Roc Nation or any other parties obtained a notice of intent to use or pay royalties for use of the songs. Thus, that brings us to the end of the story of Jay-Z, who has won his lawsuit against the cops. The cops always come in after the hip-hop artists. This time it's for the monies. They were upset about the sale of Tidal in what they say was a bad business decision because apparently somehow, some way, their pension fund was invested in the Tidal, and they thought it was a bad deal, and they're sad about not getting as much pension. Well, the Delaware court threw it out and said, go away. So I guess they'll have to be slightly sadder at the sale of that, and their pension won't be quite as glorious as it was before. Oh well. And that, for the moment, brings us to the end of discussion of this case. Push the button. Yeah. The officers, it's a pension fund. It's a pension fund, B. Jefferson. So they have a fund to fund their pensions, for when they retire. And the fund invests in things, to get money for the pension fund. And one of the things apparently they invested in was Tidal somehow. Not sure exactly how, but yeah. So, okay. That's how the cops get involved. They're sad about their pension. Let's see what else we got. Let's see. No. Florida man. No. Not now. All right, let's do a Supreme Court case. Let's do the wire fraud one. Did Rob want wire fraud? I forget. What did he say? I don't want to steal his story. Where's his comment? Where is his comment? I have to dig up this thing. Commerce clause in Puerto Rico is what he said. Okay. All right, cool. Let's do the wire fraud one. Okay. All right. Great. For today's case, we are discussing a United States Supreme Court decision that discusses issues relating to wire fraud and when a person is guilty of wire fraud. So, short definition of wire fraud is you use some sort of communication medium. Doesn't necessarily have to be wire, wireless will do, but some sort of communication medium for the purpose of fraud, which is where you basically lie in order to induce someone to give you something of value, typically money. So you use a phone line or a wire or the internet or some other transmission medium of some kind to communicate the lies to induce people to give you stuff. That's the short definition of wire fraud. Well, this person was a little bit tangentially removed from that in sort of how they were involved. They only had some right to control. So the question is this person's involvement sufficient to get them convicted of the wire fraud? Did they have enough connection to what was happening to be guilty of the wire fraud? So let's learn a little bit more about the details of how involved you have to be in order to be convicted of wire fraud. Let's get started with this. The petitioner, Mr. Ciminelli, was convicted of wire fraud for involvement in a scheme to rig the bid process for obtaining state-funded development projects associated with the New York governor's Buffalo Billion Initiative. Okay, so we got a state thing. The state would like to offer money for things, as they do. They'd like to offer monies. And this guy says, okay, I'd like some monies. And the government, of course, being government, typically does this via a bid process. So they're like, aha, we will fix the bid process. We will make it so, we win or our friends win, or otherwise we will manipulate the bid process so that it's not really a bid process. We'll come out on top. So we're going to try to fix this. Don't try to fix the bid process. That would be great. But apparently that's what they were trying to do. Investigators uncovered that a board member paid a lobbyist $25,000 in state funds each month to ensure the administration gave a person a prominent role in administration of projects. So that sounds a lot like graft, right? I'm going to give the government $25,000. I apologize. The government is going to give $25,000 in state funds each month to a lobbyist to ensure that a certain person gets a role. So the state is paying a lobbyist to lobby itself, but that's what they're apparently doing. This particular company that was involved in this, the guy that was convicted, their company paid Howe, the lobbyist, $100,000 to $180,000 each year over a series of years to help it obtain projects. So this guy owns a company that does construction. He's paying the same lobbyist the state is paying to help the lobbyist lobby for them to get the construction projects. So that's money going that way. In 2013, the lobbyist and this other guy divides a scheme where the other guy would tailor a bid process to smooth the way for the guy who was convicted to receive projects. So these guys are working in the background, right? And so the guy who's convicted would like to get some contracts. The lobbyist and some other guy are devising a project that will be tailored for the guy that's convicted, right? We are going to manipulate this project in such a way that our guy, who's incidentally giving us money to get the projects, will get this project, okay? So the lobbyist and some state official are coordinating together to give this construction guy his big break or whatever, okay? So that's what they're doing. They're doing this by designating the company of the guy who will be convicted as a preferred developer with priority status. So I'm not exactly sure exactly what that means, but it doesn't really matter very much, right? So different companies have different kinds of status, which is not atypical. Typically, like status would be based on like minority stuff or, small business. So it's not atypical for the government to give different priorities to different kinds of contractors. No, we'll give priority to local contractors as opposed to remote. We'll give priority to minorities. We'll give priority to first timers. We'll give priorities to small business, right? To help them get So it is not atypical for government to have different kinds of priorities for different kinds of people. And what they've done is designated this guy as preferred, but he's not really. They're just doing it because, basically the money that's going back and forth. All right. So now the three of them together, apparently, jointly develop a set of requests for proposals that effectively guaranteed their selection. So the government is going to publish a request for proposal, right? Please send to us, here's what we want. We would like to build a thing. We would like to build a thing. Please send to us a proposal about how you would go about doing that and how much money it will cost. Please tell us how long it will take and how much money you will spend and how much it will be and so forth and so on. Send us a request for proposal. All right. So the government is the one that issues these things, this request, but the private construction guy is now part of writing the request from the government. So unsurprisingly, he writes the request for the proposal in such a way that when the answers come back, amazingly, his construction company will come out on top. right? Because they're writing the request in such a way. What are the odds that I happen to fit into this slot so perfectly that I designed for myself, right? So we've got some private person acting in corruption with the government to put forward a proposal to benefit himself, along with the lobbyist. So we've got government official guy, lobbyist guy, and private construction guy now jointly involved in a conspiracy that now includes the request for proposals that they themselves will fill out, of course, to satisfy themselves. So that's what's happening now. Okay? With the status in hand as a preferred developer, which would also be given to them, they secured the $750 million project called Riverbend Project in Buffalo. All right? So the project was worth $750 million. So the company that spent $100,000 to $180,000 each year for a lobbyist is getting one hell of a return on their investment. Okay, they spent $100,000 to $180,000 every year, in exchange for which they have now gotten a $750 million contract. But of course, it wasn't just I hire a lobbyist. It was, how about me and the lobbyist and the government together as part of a conspiracy design the requirements for the project in such a way to benefit me. And also, by the way, how about you give me preferred status on top of that? So that amazingly, when it all comes together, what are the odds I was awarded this $750 million contract? So, you know, a little bit of corruption in my New York. Corruption in my New York, it's more likely than you think. All right, so after all this was uncovered, the three individuals who are part of this grand conspiracy were indicted for a whole bunch of things. But as particularly relevant to this appeal, they were convicted of wire fraud and conspiracy to commit wire fraud. All right, so the question at the moment is this question of, can this guy be indicted, convicted for specifically wire fraud and conspiracy to commit wire fraud? He may be guilty of many things. But the question is whether or not he can do this specific thing. Hi, Rob. How are you doing?
Hey, buddy. How's it going?
Good. So would you like to just join me as I sort of continue this description and then we can do another one?
Absolutely.
Great. All right, so Rob is here. Fantastic. Hello, everyone. Say hello to Law and Lumber, our friend Rob, who kicks ass and is great. You should go check out his channel, Law and Lumber. All right, so we're trying to figure out whether or not this, have you heard this story or do I need to give it to you? The basics. Do you know what's going on in this?
I'll catch up. I think I caught enough of it. There was some fraudery going on.
Okay, we got a private construction guy, a lobbyist, and a government official that together conspired to put forward a request for proposals for a construction contract that, of course, the private guy being involved in was able to write the request in such a way that, of course, his construction company would unsurprisingly get the deal. It was a $750 million deal.
Ooh, okay.
So, yeah, so they're involved in a conspiracy for the construction project, and we're trying to figure out at this precise moment whether or not the construction guy can be convicted of wire fraud and conspiracy to commit wire fraud. That's the question the U.S. Supreme Court is trying to solve at this exact moment. So let's do that. So in the indictment, the government relied on the Second Circuit's right to control theory of wire fraud. So why are you guilty of the wire fraud? The only theory put forward by the government at trial was right to control. So that this guy had the ability to control what happened. So he is the mastermind, if you like. He may have not himself done the wire fraud, but he directed the wire fraud. He's the kingpin of the wire fraud, right? Theory of right of control. So under this theory, the government could establish wire fraud by showing that the private construction guy schemed to deprive a victim of valuable economic information necessary to make discretionary economic decisions. So under this theory, the way the government did it, it's not even in this particular context that he lied exactly. It's not that he sent out false information. The government's theory of this particular crime is that he didn't send out information. He withheld information that would have allowed a person to make an economic decision that if they had that information, they probably wouldn't have made. And also, not only is it that he didn't send out information, also he's one step removed. So it's not that he himself did it.
This is criminal. This isn't civil recourse, right? This isn't the government.
Yeah, this is all criminal.
Money on a bad bid. This is criminal.
This is all criminal. Yeah, this is criminal wire fraud.
Okay.
So we're not sending information and we're one step removed. So that's what's happening. Consistent with the theory, the district court instructed the jury that the term property, for the purposes of fraud, includes intangible assets, such as the right to control assets. So what is property is always a good question. In this domain, an intangible asset, okay, that makes sense, but also the right to control the intangible asset, because that's part of the bundle of sticks of property rights, right? Your ability to control. Mm-hmm. So like if you have the ability to control the property, then you have an ownership interest in the property. So that should be sufficient, says the Second Circuit. This could be harmed by depriving people of information. So by not giving them information, you are impeding their ability to control their assets because you're lying by omission. The jury convicted him of wire fraud and conspiracy. On appeal, he argues the right to control is not property for the purposes of the statute. So that's not sufficient to be property. The Second Circuit affirmed on the basis of longstanding right to control, because this was all based on Second Circuit precedent. And so the Second Circuit said, yeah, we were right the first time. All right, so the US Supreme Court comes to the rescue and says, because right to valuable economic information need to make a discretionary decision is not a traditional property interest, the right to control cannot be the basis of conviction. So the Supreme Court disagrees. Right to information is not a property interest, which kind of makes sense because property is me taking something away from you, like it's something you own. Here, it's me not giving something to you, right? And so I'm lying by omission.
Well, in most cases, you have a combination of property interests. You're not usually tying your entire case on one of those elements to property ownership.
Yeah, so for whatever reason, the federal government has tied itself to a very narrow theory of the crime, and they're unable to make that work. It's like my right to control my property is a property interest of mine, but if the way you're depriving me of that property is by not giving me information, that's not sufficient under the federal law. So that's too tangential. The federal wire fraud statute criminalizes the use of interstate wire by any scheme to defraud, obtain money or property by false pretense, representation, or promise. I lied to you to induce you to give me a thing. When federal wire fraud statute was enacted, the common understanding of defraud refers to wronging one in his property rights. You know, I'm tricking you out of your property. The court, therefore, has consistently understood the statute's money or property requirement as limiting the scheme or artifice to defraud. So the scheme or artifice to defraud, my scheme to defraud, must necessarily not just be a free-floating scheme. It must be a scheme specifically with respect to money or property, right? So it can't be a free-floating scheme and also money exchanges hands. The scheme has to be tied to the money, which makes sense. Even so, lower federal courts for decades interpreted the statute to protect intangible assets unconnected to traditional property rights. The Supreme Court halted this trend in a case called McNally, which confined the statutes to protection of individual property rights. So how about the intangible rights? The Supreme Court's like, no, less so with the intangible rights. That's not what the statute had in mind. So this right to control theory cannot be squared with the text of the statute, which is limited in scope of protection. The so-called right to control is not an interest that's long been recognized as property in and of itself when wire fraud was established. So the fact that you control property is not sufficient to give you a property interest in and of itself. From the theory's inception, the Second Circuit has not grounded the right to control in traditional property notions. The theory is also inconsistent with structure and history of the federal fraud statute. Congress responded to the decision by enacting a different statute, which revived only the intangible right of honest services fraud. So Congress, in response to less with the in the intangible property wrote a new statute, which they can do, and said, okay, we'd like to put in place the honest services fraud, but just that one apparently. So Congress, making choices, said just that. Congress's silence with regard to other stuff, well, that can't be the basis of conviction because that would be dumb. Finally, by treating mere information as an interest unto itself, the right to control theory vastly would expand jurisdiction to almost limitless variety of deceptive acts traditionally left to state law. So again, state law might have to have a word with you, but not on the federal law. Despite exclusively relying on right to control, the government now concedes the error as articulated below is erroneous. So even the government argument had to say, yeah, that doesn't make any sense, but it's okay, we can fix it. The government insists that it can affirm the conviction by applying facts presented to the jury below the elements of a different theory of wire fraud. Anyone have a notion about why it might be a problem to twice try the same guy for the same crime? Anyone have any issues with that?
Maybe it might be kind of something that begins with like a D and like a J, like a
yeah.
double.
Yeah. The court declines this request because, no. And it's unanimous, unsurprisingly. So the government's theory falls apart, and they're like, it's okay, we could win a conviction under a completely different theory of the crime if we could just go back to trial and present it to a jury.
Mm-hmm. Unanimous.
Thus, that brings us to the end of the discussion of this case, which deals with a fairly esoteric and narrow issue under federal wire fraud. So to do the wire fraud, you have to deprive someone of property, which typically and exclusively means a tangible thing or an asset that it would be tangible. So like money. If you still have a bank account, obviously money is money, or property or something. But this intangible asset, this right to control, is too removed. So not so much with the wire fraud and conspiracy to commit wire fraud, because it doesn't fall within the technical definition. So you're guilty of, I'm sure, many, many, many other things, but hey, you win that one. And that brings us to the end of discussion of this case.
We're flexing the brain muscle today, aren't we?
That's why Supreme Court is best. That's the
gosh.
best. Sir. Yeah, that's the best. All right. So you have your choice. Which would you like to start with? Would you like Puerto Rico, or would you like Nightmare Fuel, Split Decision, Marks Analysis, or Commerce Clause?
I remember this being argued and just going, this is a mess.
Yes. Apparently the decision isn't much better.
Oh, well, what's the split?
Well, figuring out how to count is a problem, actually.
Oh no, one of those.
What is the split? That's a good question. Hold on. Justice Gorsuch announces the opinion of the court with respect to parts 1, 2, 3, 4A, and 5, in which Thomas, Sotomayor, Kagan, and Barrett join, with an opinion with respect to parts 4B and 4D, and Thomas and Barrett. And Barrett also joins with respect to part 4C, in which Thomas, Sotomayor, and Kagan join. So you tell me. Sotomayor concurs in part. Barrett concurs in part. Roberts concurs in part and dissents in part, in which Alito, Kavanaugh, and Jackson join. Kavanaugh files an opinion concurring in part and dissenting in part.
Wait a minute. Alito, Kavanaugh, and Jackson are the same with Roberts? That's a weird bunch.
Yeah.
Okay, let's go.
Nightmare Fuel. Nightmare Fuel. Nightmare Fuel.
On the bacon.
All right, we're going to try to figure this out, guys. This is going to be fun.
Oh, God.
How good are we? Let's find out. Real time, no problem. All right. For today's decision, we've got a case of national pork producers versus the Department of Food and Agriculture of California from the United States Supreme Court. So what happened in this case is the state of California put in place standards with respect to how pigs are raised and how pork that comes from that pigs are sold. So California said, okay, if you want to sell pork in our state, it must come from pigs that are kept in this particular way. You know, they must be kept in pens this big, they must be kept this way, blah, 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 right? This is how the pigs must be kept. Well, of course, as is relevant, these standards are stricter than federal law would require. All right, California is putting in place more onerous requirements with respect to how the pigs are kept. So this poses potentially a bit of a problem because now other states have a bit of an issue when it comes to selling to California, which of course is a major market. So this trips what's called the Dormant Commerce Clause of the Constitution. The United States Constitution gives the power to control interstate commerce to Congress. Congress is the one that gets to say how interstate commerce is done. So that is the Commerce Clause, but the negative implication is called the Dormant Commerce Clause. If Congress has the power to control commerce, then by implication, any individual state does not have the power to control commerce, okay? So you run into this problem, but you also have the idea that states get to control their own state law. So now you are in this balance, okay, where you have these issues. So a state puts in place a regulation or a law that in some way would reflect interstate commerce and make that trade less common. All right, so under what circumstances can you do that? All right, how do you determine if you can do that? So that's what this case is about. Did California go too far in its regulations in such a way that puts an undue burden on other states' ability to sell pigs to California? And it's a nightmare fuel, split case, split decision, trying to figure all this out. So we are going to read this and understand it, no problem. Let's get started with this.
Pause. I'm so hungry now that we're talking about pork. What's a good lunch decision today? Is it barbecue? Is it barbecue? Is it like a sandwich? I'm trying to figure this out because I gotta figure this out before we get going because I'm just gonna be starving the entire time.
Pork sandwich, put some coleslaw on it, you know. Get some baked beans.
Phenomenal idea. This is now my go-to. Good. There we go. All right, we can proceed.
All right. This case involves a challenge to a California law known as Proposition 12 because, like so many of these things, it started out with a voter because, well, California, for better or worse, allows its voters more control when it comes to these citizen petitions. And sometimes the things they come up with lead to some interesting legal consequences, as one would expect. So the California voters voted on this thing, which is relevant here, would forbid the sale in California of pork meat that comes from pigs that are confined in what California considers to be a cruel manner. So the way that they're kept, California considers to be cruel. The relevant law says it would be cruel if it prevents a pig from lying down, standing up, fully extending its limbs, or turning around freely. The relevant law came into place because proponents suggested the law would benefit animal welfare and consumer health, and opponents claimed that existing farm practices did better than this with respect to it. So it's not necessary and would be counterproductive, and we like the ability to sell pigs the way we already do. Thank you very much. Shortly after the adoption, two organizations, the National Pork Producers Council and the American Farm Bureau, filed this lawsuit for members who raise pigs in other places, alleging that the relevant law violates the U.S. Constitution by impermissibly burdening interstate commerce. That is the language that you're looking for. Impermissibly burdening interstate commerce. Dormant Commerce Clause. Congress gets to regulate commerce. States do not get to regulate interstate commerce. So it is illegal if it impermissibly burdens interstate clause. What makes it permissible or not? Let's find out. Petitioners estimate the cost of compliance would increase production costs and would fall on both California and out-of-state producers. One of the ideas being, of course, that they would have to raise their pigs, all their pigs, in a way that would be compliant with California law, which would also increase the price of pork in other places. Because California is such a huge market, right? It would become impractical to raise certain pigs some ways for California, other pigs for other markets. So the most efficient solution would be to raise all the pigs compliant with California, but that would raise costs not just in California, but nationwide. because it would put it more of a burden. So costs would go up everywhere. So consumers in Illinois suddenly have to pay for California's choices, potentially. But because California imports almost all the pork it consumes, yeah, there's very little pork made in California. I forget exactly what the number was, but it's like less than 1%. It's very, very low. Most of the compliance costs will be borne by out-of-state farms. The district court held that petitioners failed to state a claim. The Ninth Circuit affirmed. U.S. Supreme Court agrees. So there is no problem. Everything is fine. California can do this. We don't need to think about it any harder. Yeah, okay.
I'm skimming. This is a nightmare.
Yeah. The Constitution vests Congress with the power to regulate commerce among the states, interstate commerce. Although Congress may seek to exercise this power with respect to pork, and many pork producers have asked Congress to step in, Congress has not placed a law that would explicitly overturn this. So this little piggy go to market, this little piggy go home, and this little piggy go wee, all to the houses of Congress. But Congress decided not to act on the pork-related petition. Petitioner's theory thus rests on the Dormant Commerce Clause theory, pursuant to which Congress not only has the power to regulate interstate commerce, but also the contra, which is that states can't do that. This court has held that state laws offend this aspect when they seek to build up domestic commerce through burdens on industry and businesses of other states. So one of the ways we look to see if this is improper is if what you're trying to do is favor your own children. You know, we are trying to pass a law that will favor California producers more than other producers. We're trying to build up our own industry. So it's like, no, you can't do that. All right. At the same time, the court has reiterated that absent purposeful discrimination, a state may exclude from its territory or prohibit the sale of articles which in its judgment are prejudicial to the interests of its citizens. So as long as we are not trying to help our own children, the wonderful citizens of New York, as long as we're not trying to, discriminate in this respect, then we have the right to exclude things from our state boundaries if we wish. Great. This anti-discrimination, yeah?
You said New York, and I know you were going to the New York cows case, the dairy.
Did I say New York?
Yeah, I knew exactly where your head was too. Dairy cows in New York.
New York, California, pigs, cows, it's all the same, damn it. The anti-discrimination principle lies at the very core of the court's domination.
Dormant.
The anti-discrimination, what?
Dormant commerce.
I know, I'm working on it. The anti-discrimination principle lies at the very core of the court's Dormant Commerce Clause. This court has said that the clause prohibits enforcement of state laws driven by protectionism, that is, regulatory measures designed to benefit in-state interests by burdening out-of-state competitors. So again, are we trying to favor our own children? Petitioners here disavow any discrimination-based claim, contending the law imposes the same burden on in-state producers as it imposes on out-of-state producers. So it's the same law that burns everyone everywhere, but that in and of itself is not going to get you past this because the courts are not this dumb, right? We've written a superficially neutral law that applies to everyone everywhere, but we know that as a matter of practical reality, this law will have different impacts. And so it's like, we're not going to say that California pork is best pork. We're going to say best pork is pork that meets these criteria, which just so happens to be California pork. By mere coincidence, what are the odds, right? We're not this dumb. So just the fact that it's neutral is not going to get you past this. Given the fact that they say it does not implicate the anti-discrimination principle, they try to get around this problem by saying it's extraterritoriality. So California is trying to regulate outside its own territory, which obviously California can't do. California can only regulate inside its own borders. So it can't pass regulations that extend outside its borders. They contend the court's Dormant Commerce Clause analysis suggests additional and almost per se rule that forbids enforcing state laws that have the practical effect of controlling commerce out of state. California cannot regulate in Illinois, even where those laws do not purposely discriminate. So even if discrimination is not the problem, we can't regulate outside our own boundaries. All right, let's try that argument. Petitioners insist the law offends this per se rule because the law imposes substantial new costs on out-of-state producers who wish to sell their products in California. Petitioners contend this rule they propose falls from 3 different cases. So we say, okay, we've got precedent 3 different ways. But a look at those cases reveals that each case typifies a familiar concern with preventing purposeful discrimination. So the Supreme Court says, okay, you've actually misread our case law. The issue isn't extraterritoriality in these cases at all. The issue is discrimination. So you have misread our precedent. In the relevant law from New York with the dairy farm producers that Rob mentioned earlier, New York tried to bar out-of-state dairy producers from selling their milk in the state for less than a minimum price New York guaranteed by law. That would discriminate against out-of-staters by erecting an economic barrier protecting a local industry. So they set a minimum price for the thing, and that not so much. You can't do that. In a different case, the New York law required liquor distributors to affirm their in-state prices were no higher than out-of-state prices. And this impermissibly sought to force out-of-state distillers to surrender cost advantages to what? So different markets have different prices, not for the least of reasons, incidentally, because of different regulations. So maybe the reason the price is higher in New York than other states is because New York, as a matter of its own state law, has put in place additional compliance requirements, which increase costs and inhibited the market in increased costs. Some states allow anyone to open a liquor shop. Some states say only the state can do it. Some states say you can only sell this kind of alcohol in this kind of store, or only this kind of way. Some states have labeling requirements or taxing requirements or whatever. And maybe those are the reasons the price is high. But New York tried to get around this problem, not by saying let's lessen our regulation and being competitive, but let's simply require other states to have the same price so that people won't go out of state to buy liquor. So we won't be burdened by our own dumb choices because we were the one that made it expensive in the first place. So, that's dumb because other states, are regulating it differently and the price is cheaper and, you can't force them to have higher prices. No, that's dumb. As the court rather explained, in Connecticut, they hoard commerce for the benefit of in-state merchants and discourage consumers from crossing state lines. I bet they do try to discourage it, but people are free to travel. So maybe solve this problem by not having as much regulation would be great. Petitioners insist that these laws, taking these cases together, establish a rule that state laws with Petitioners insist that these cases taken together establish a rule that extraterritoriality is invalid. While petitioners point to language in these cases regarding practical effects, the language of an opinion is not always to be parsed as though we're dealing with the language of a statute. So that's fair enough, right? The Supreme Court writes things, and they write things in a way to express ideas, but their exact words sometimes are not as important as the ideas. They're not to be parsed like a statute. So yes, they have talked about out-of-state effects, but that didn't mean that they were talking about extraterritoriality. They were talking about discrimination. So, you're focusing on the words versus the idea.
You think Gorsuch could hide his skepticism any better? I mean, he's kind of going ham at it. I think he's used it almost per se rule. He's quoted that text like 4 times.
Yeah. Yeah.
Okay.
I think they have some hostility to the concept.
I would believe so. Plus, say extraterritoriality like 5 times fast. Extraterritoriality.
Extraterritoriality. Damn it. Okay. A closer look at the cases, because you can't read our cases because you're idiots. Ha ha ha. You can't read our language, you stupid people. A closer look at these cases reveals nothing like this. So no. And the petitioner's reading would cast a shadow over laws long understood to represent valid exercise. So no, you're completely misreading our law. You suck at reading, try harder. The relevant cases did not mean to do this much. In rejecting the petitioner's theory, the court does not mean to trivialize the role territory and sovereignty barriers play. The Constitution takes great care to provide rules for fixing and changing state borders. Fair enough. So the borders are the borders, and states can only operate inside their borders. So we do take note that California is California and not Nevada, for example. Courts must sometimes referee disputes about where one state authority and another begins, both inside and outside commercial context. Yeah, the Supreme Court unfortunately is burned with that role a lot. They have to help the children when they squabble, which happens somewhat frequently. Indeed, anti-discrimination principles found in the Dormant Commerce Clause analysis may well represent one more effort to mediate these claims. But none of this means that any question about an ability to project its power must yield to almost per se rules. So basically, states may have some out-of-state effect, but that doesn't itself mean that's a problem, because basically, especially today, it would be very difficult to write a statute that would have no out-of-state impact. That would be difficult.
Couldn't do it.
In the modern era, with modern commerce and people's ability to travel through states and our nationwide network, writing a statute that had only intrastate effects would be difficult. So if we said that basically would prevent states from doing stuff, and that would be really dumb. This court has never claimed so much ground for judicial supremacy under the barrier of dormant commerce. So no, that is not what that means. Petitioners then point to a different case, which they assert requires the court to at least assess the burden imposed by a state law and prevent its enforcement if it's clearly excessive in relation to benefits. So maybe we'll do some sort of balancing analysis. Let's look at how much it burdens localities in your own state versus out of state. And maybe if it's too much out of state, then maybe that's the problem.
It's a slippery slope. Court doesn't want to do that.
Petitioners provide a litany of reasons why they believe this relevant law secures for Californians do not outweigh the costs it imposes on outstate of costs. So whatever benefit you're getting is more expensive than the costs you're imposing outside your borders. The Supreme Court chides petitioners by saying they overstate the extent to which Pike and his progeny depart from this rule. Overstate the extent. That sounds like minimized language. That sounds like a bench slap to me. Overstate the extent sounds like you're an idiot.
This thing does not say what you think it says.
You're a complete moron.
You keep using that word. I don't think it means what you think it means.
Overstate the extent is Supreme Court for you fool. They overstate the extent to which the law rule lies at the core of the court's dominance. As this court has previously explained, no clear line separates that case from core anti-discrimination precedent. If some case focuses on whether a law discriminates on its face, which, fair enough, if you can figure it out on its face, then great, then that case Pike serves as an important reminder that a law's practical effects may also disclose discrimination. So it's not the burden in and of itself. It's not the burden is higher on out of state. That is evidence of discrimination. The test, the Supreme Court is trying to tell you as they beat you over the head repeatedly with the stick over and over again. How can you not read? How can you not read? The relevant test is discrimination, okay? Yes, you may be able to determine that from the burden, but it's evidence, not the conclusion, okay? So stop doing this. It's discrimination, you fools. That's the standard. The relevant law also concerned itself with an Arizona order requiring cantaloupes in the state to be processed and packed in state, okay? So in that case, Arizona said, I don't know why, but this is apparently what Arizona wrote with their free time, okay? We think that all cantaloupes sold in the great state of Arizona should be packaged within Arizona. How do states think of this law? Why on God's earth is the Arizona state legislature with their time saying, you know, it would be great. What if all the cantaloupes were packaged in Arizona?
Pack it here. Yeah, if you grow it here, you got to pack it here, basically.
Who thinks of this stuff? Apparently the Arizona legislature does. Okay. All right. Anyways, that's what they did. The court held that this law violated Dormant Commerce Clause, stressing that even if the order could be fairly characterized as facially neutral, it required business operations to be performed in the state that could more efficiently be performed elsewhere. The practical effects thus revealed the discriminatory purpose. Discrimination. Okay? Discriminatory purpose. An effort to insulate in-state processing from out-of-state competition. Right? If we require all the stuff to be packaged in-state, then our in-state producers will obviously package a lot more stuff, even if it's more expensive. Maybe out-of-state producers are packaging more because it's cheaper, because of regulation. Maybe we should change our regulation. But what if we force them to package here? No. While a small number of our cases have invalidated state laws that appear to have genuinely non-discriminatory purposes, this falls well outside whatever that is. So no. The framers equipped Congress with considerable power. So once again, if you really think this is a problem, go tell Congress about it. Because Congress, as we know all too well, has insane amounts of power when it comes to interstate commerce. So, you know, go tell Congress about all your needs and they will fix you right up. While this court has inferred, possibly. While this court has inferred an additional judicially enforceable rule against certain state laws adopted even against the backdrop of congressional silence, because of the discrimination, for example, the court has also suggested extreme caution. So, Dormant Commerce Clause is a sort of extreme thing, right? It's not no state can impose on another, because that would be basically borderline impossible, right? This is to be exercised cautiously, not freely, all right? This is a sort of reserve idea. It's negative implication, incidentally, from the constitutional text. So, you know, we don't do it that much. Disavowing reliance on this court's core Commerce Clause teachings, focusing on discriminatory state language. How many more times do you think they can use the word discrimination?
I don't know. And how much more shade can Gorsuch throw in the direction of petitioners? Disavowing reliance on this court's core Dormant Commerce Clause teachings, petitioners invite the court to endorse new theories. Wow.
Petitioners, you don't know how to Supreme Court. You're really bad at Supreme Courting. You don't know how to read. You don't know how to argue. You don't know how to Supreme Court. You're a bunch of idiots. This is some serious shade. This is a lot of shade. You're really dumb. Okay. They would have this court impose an almost per se.
Again, there it goes.
You're right again. Against enforcement of state laws that have extraterritoriality effects, even though it's long recognized that virtually all state laws create ripple effects, because of course they do. Alternatively, they'd have the court prevent a state from regulating the sale of ordinary consumer goods within its own borders on non-discriminatory terms, even though the relevant law of cases they invoke has never before done this. So, no. Your theories are novel and stupid. Like the court that faces case, like the court that faces place below, the court declines both in cautious invitations. Wow.
Oh, the shade. Oh my God, I love Gorsuch's writing.
Wow. That's serious shade. You have disavowed our decisions. Your suggestions are incautious.
Respectfully speaking, children, we gave you all of it.
They overstate the extent to which our case law speaks on this issue. Holy shit. Holy shit, dude.
This is wild.
Take a shot every time they use the words extraterritoriality or per se or discrimination. Holy shit. Anti-discrimination lies at the very core of our jurisprudence.
Oh my God.
Oh man.
All right, so
that
was as to parts. Let me see here. That's not just affirming the ninth. So the ninth comes in with this ruling, and you have that strong of an opinion affirming the night. That's pretty interesting. Whereas Gorsuch delivers the opinion in a court joined by whom?
Gorsuch, Thomas, and Barrett's conclude that the balancing test would be inappropriate for any court to do. That's so. Gorsuch, Thomas, Sotomayor, and Kagan conclude that the allegations are insufficient as a matter of law to demonstrate a substantial burden, as showing that requires before a court may impose this. Gorsuch, Thomas, Barrett conclude that the petitioners not ask the court to treat punitive harms as freestanding harms cognizable. So your entire claim is fundamentally uncognizable from first principles. That's really bad shade. So it's basically basically, if I'm reading this right, it's just disagreements over how stupid you are. So the majority agrees you're stupid, and then a couple of justices argue about how stupid you are.
But this opinion is a mess. But look at these votes and the combinations and where they're joining and parting. I mean,
yeah,
this is one where the court was
Gorsuch, Thomas, and Barrett conclude, the welfare thing, we read that. Sotomayor, Kagan conclude the judgment should be affirmed, not because the courts are incapable, but because petitioners fail to plausibly allege a burden. Wow.
See, that tracks. Sotomayor and Kagan would have done it. They would have gone and slapped down states kind of governing within their own territory. What's Barrett say?
Barrett concludes that it should be affirmed because the burdens to be cognizable, the benefits and burdens are incommensurable, and plausibly allege a substantial burden on interstate commerce because it fails to be felt primarily outside of California. So basically, it seems like, if I'm reading this properly, it's actually 9-0, and it's just disagreements over how stupid you are.
It does look like that. But you know what? The test, we still have no freaking clue what the test is.
No, the Dormant Commerce Clause analysis is a bit... Well, I think it might have something to do with discriminatory purpose.
Oh, you think so?
I think going forward that lawyers would be well advised to root their Dormant Commerce Clause analysis in discriminatory purpose. I seem to be mentioning that several times, so I got that much of the note. So, yeah.
That was great. That was remarkably entertaining.
Yeah. Who says law can't be fun? Who knew? This is what people outside law don't appreciate. They don't appreciate how much fun regulation of pigs in pens can be, and how much shade can come from it. Pigs should be in pens this big, not this big, and the amount of shade that comes from it is enough to blanket the entire state of California in perpetual cloud. Or more to the point, every other state, because California is in the right. So California gets to have sunshine, and the other states can sit under the clouds like bad states that they are.
Just, oh my gosh. Do you want to tackle Puerto Rico? Because that's a mess.
Oh no, I understand this. Have you seen anything about this?
I have listened. So this is one of several Puerto Rico cases at the Supreme Court and the appellate courts right now.
Yeah. No, there's a couple. That's true. So this one deals with this board and bankruptcy. So right up your domain of stuff.
Let's do it.
All right, let's go.
I'm dying for this. I love opinion release days. Give me one sec. They're my favorite.
Okay. Rob is coming back. While he's coming back, just a friendly reminder to please hit that like button, share on social media, tell your friends about it. We're having way too much fun over here on Uncivil Law Land. This is good shit. I'm sorry to hear you were unsubscribed during the stream. That sucks hard. YouTube does seem to do that sometimes. It's one of the reasons I keep encouraging you guys to share and reshare on social media, because we have to do things to try to counter whatever YouTube is doing as it relates to this. So I need you guys to help, please. And the best way that you can help probably is by sharing on social media, like Twitter, or retweeting on Twitter. I think it's probably the best way you can help, because we need to find ways outside of YouTube to help drive traffic. Or you could subscribe to my TikTok or Instagram, since we're now posting shorts there. That would also help, because the more people that see those shorts, some of those people might be intrigued to come over to the channel. So subscribe to the TikTok, subscribe to the Instagram, share on Twitter. We need to find ways outside of YouTube to help drive traffic to the channel. And these are the methods that I've chosen, so please help with that.
It wasn't sandwiches, it was documents.
Okay.
It was a box of documents.
Documents are less fun than sandwiches.
They are.
When you send over Discovery, do you include like chocolate and stuff, or like some
I should
flowers?
start doing that. I think I should start doing that. Yeah. I need sandwiches to make that less depressing. Okay.
All right. For today's case, we turn our attention to Puerto Rico, which has been before the United States Supreme Court a bit recently in a couple different cases dealing with issues from Puerto Rico, which might ultimately impact issues relating to Puerto Rico and the relation to the United States. There's this series of cases called the insular cases, which basically say that Puerto Rico and other territories of the United States aren't really subject to the Constitution the same way that states are. And these cases have become increasingly uncomfortable in recent years. The Supreme Court has taken a look at this kind of recently, and although they haven't said so yet, it looks like the Supreme Court might at some point in the near future say the insular cases are no longer good law, which, by the way, the cases themselves in their own cases said those decisions were only supposed to stand for a time. And that was 120 years ago. So it's been a little bit, man. The Supreme Court itself said it was supposed to be time limited, and that was 120 years ago. So, maybe now would be good. Anyways, turning our attention to the immediate issue, we turn our attention to a financial crisis of Puerto Rico, a bankruptcy, and whether or not Puerto Rico has sovereign immunity with respect to these issues. So let's get started with this. In 2016, Congress passed a law called the Puerto Rico Oversight, Management, and Economic Stability Act to deal with the financial crisis in Puerto Rico. Of course, Puerto Rico, not being a state, is governed by United States law. So United States Congress, of course, has the ability to just do whatever the hell they want and just pass laws for Puerto Rico. And that's what they did. The relevant law established a system for overseeing Puerto Rico's finances, while also enabling Puerto Rico to gain bankruptcy protections similar to those available under the bankruptcy code. So Puerto Rico would have the ability potentially to avail itself of bankruptcy law. The statute created a financial oversight and management board for Puerto Rico. The petitioners, in this case, as an entity within the territorial government of Puerto Rico. So some people are citizens of Puerto Rico, or they live in Puerto Rico, and they have some issues with this. Under the relevant law, the board approves the Commonwealth's plans and budgets, supervises its borrowing, and represents Puerto Rico in Title III cases before a federal judge, relating to debt restructuring modeled on federal bankruptcy proceedings. So this board established by Congress is Puerto Rico with respect to these financial issues. Congress has taken away from Puerto Rico its ability to manage its own money and given it to this congressionally controlled board, and it is Puerto Rico with respect to these issues. Beginning in 2016, the Respondent, a nonprofit media organization that reported on the financial crisis, asked the board to release various documents. So there are, this board is doing some stuff relating to management of money. We'd like to know more. Can we have some transparency, please? The board moved to dismiss the request under sovereign immunity grounds. We don't have to give you the document because you're asking a sovereign entity, the government of Puerto Rico, to produce it, and we don't have to. The district court said no, not so much with the sovereign immunity. The First Circuit affirmed. The court began by citing circuit precedent, And I always like that fact that Puerto Rico is part of the First Circuit. I just find that hilarious because the First Circuit is New England, it's Maine, and it's Massachusetts. But somehow, for some reason, Puerto Rico is part of the First Circuit. You think it would be part of the 11th Circuit, like part of Florida, but no. For legal purposes, Puerto Rico is next to Maine. I always find that funny. Anyways, Puerto Rico, which is next to Maine, the First Circuit said, you can't have this. The board began by citing its precedent that Puerto Rico enjoys sovereign immunity and assumed without deciding the board shared its immunity. So Puerto Rico is sovereign in this respect. The board is Puerto Rico, therefore also sovereign. That's what the First Circuit said. But then it held the relevant law, particularly jurisdictional proceedings, clearly abrogates the immunity. So this is the question, right? So Puerto Rico, in this context, has immunity. The board is Puerto Rico. So therefore, you would think the board also gains immunity. But the First Circuit thought that the statute abrogated immunity, which Congress could also do. They can say, yes, we can be sued on this issue. So the question is, did Congress say, yes, we can be sued? The Supreme Court says no, not so much. Nothing in the relevant law categorically abrogates sovereign immunity the board, which is Puerto Rico, would enjoy. The court assumes without deciding that Puerto Rico is immune from suit, and the board partakes. I love how they also assume without deciding. That's also hilarious. So we don't want to go down that road. Yeah, we're not going down that road. We are definitely not deciding whether or not Puerto Rico has sovereign immunity. We are not touching that. We'll just assume they do because no one bothered to ask us whether or not they have sovereign immunity. So we'll just take it as a given and in absolutely no way get down that can of worms because, well, that's a whole nightmare.
We don't want to touch that.
We don't want to touch that.
We've kicked that can for 125 years.
Yeah, we're kicking it further. We're kicking it further. The court has often held that Congress must make its intent to abrogate unmistakably clear. The court has applied the clear statement rule in cases naming the federal government, states, and Indian tribes as defendants. And it's found the standard is met on only two situations: where a statute says that is stripping immunity, and where a statute creates a cause of action and authorizes suit against the government. So either the statute says the state isn't immune, or it says, here's a way to sue the state, which necessarily implies the state isn't immune, because that would be extremely dumb. Here's a way to sue the state, but the state's immune. That'd be stupid. So one of those two things. The relevant law fits neither of these molds. Except by reference to bankruptcy code, debt restructuring provision, the relevant law does not provide that the board is subject to suit. So the board has the ability to take advantage of bankruptcy because that's what Congress wrote. You can do some bankruptcy stuff now. Bankruptcy obviously is governed by federal law because the Constitution says it is. Congress has the ability to make uniform laws for the bankruptcy. That might be a provision you've read before, Rob. In the Constitution. Yeah. So they have the right to make the uniform rules for the bankruptcy. So they can abrogate state issues on that because that's what uniform rules mean. So they said, hey, Puerto Rico, you get some access to the bankruptcy. That's nice. That Puerto Rico has access to the bankruptcy does not suddenly mean that they no longer have sovereign immunity, because that'd be really stupid. No. Nor does it create any action against the board. Thus, Congress has not unmistakably abrogated. So no, not so much. You can't sue Puerto Rico because we assume they have immunity. Yeah. The claims that identified a clear statement establish a judicial review scheme. The relevant law provides that any action against the board and any other action otherwise arising out of it shall be brought in federal district court for Puerto Rico. So Congress, when it created this board, said, hey, if you want to sue relating to this, probably sue us in federal court in Puerto Rico because, Puerto Rico. So that would probably be a good place to sue if you have a problem. Sue us there. In the petitioner's view, that provision, especially when combined with the allusion, nice, that's nice, to declaratory injunctive relief, contemplates the board will be subject to suit. But those provisions serve a function even absent categorical abrogation of immunity in cases where the board's immunity has been waived or abrogated by other statutes. So it may be true that the board is subject to lawsuits for other statutes, because in other statutes, the Congress wrote that states or territories are not immune. So yes, you can sue the board and therefore Puerto Rico for other reasons. Because you can sue them for other reasons doesn't necessarily mean you can sue them for this reason, though, because again, that would be dumb. For example, Title VII of the Civil Rights Act abrogates immunity of governments from actions authorized. So if you'd like to sue for discrimination in the workplace, you can sue states or Puerto Rico for discrimination in the workplace, because that's what the law says. If a board employee were fired because of race, the relevant law would tell the employee where to bring suit, Puerto Rico, and the relevant law would govern the timing of relief. So sure, sue Puerto Rico for the race-based discrimination. That would be fine. Nor does provisions the law provides the board from litigation fill in the gap. So the board also has the ability to litigate in some circumstances because, it's an entity and has the ability to bring suits, for example. Again, the people are wrong to think these provisions are superfluous unless the law generally abrogates immunity. Wow. That's such a nice word. Superfluous. I like that word very much. So these laws would be pointless unless it generally abrogates immunity. And the Supreme Court's like, what are you talking about? That doesn't even begin to make sense. The relevant law says, here's some places you can sue. And the people say, well, that wouldn't make any sense unless you have general power to sue. And the Supreme Court's like, what are you on? That doesn't make sense.
What are you on?
You don't have general power to sue. Here's some specific places you can sue. Makes total logical sense. The general rule is you can't sue. The specific rule is you can sue for these reasons. Well, that wouldn't make sense unless you could generally sue. But if you could generally sue, why would we need to say that you could sue for these reasons? Because you could generally sue. So it's kind of exactly backwards from what you said. That's how dumb you are. The relevant law for liability, respecting monetary liability for the board, would do work whenever some other law was in place. So you might be able to get monetary relief if, you could sue for some other reason. In such a case, a claim could go forward, but the relevant law would apply. And the relevant bar on challenges to fiscal and budgetary decisions would do work whenever they sought to get around sovereign immunity. So, you can't do that. You can't sue them. So no, nothing abrogates immunity. The statute does not explicitly strip the board and go away. Kagan delivers an opinion for an 8-1 court. So
Look at that.
Thomas apparently disagrees. Would you like to know why Thomas disagrees?
I'm curious. I was just scrolling down to his. So argue the petition lacks state sovereign immunity because they apply that it has low immunity. Nothing abrogates corporal law bound by certain personnel. Oh, Thomas wants to take on the immunity. There's Thomas. He's like, let's do it. Because I would reach the antecedent question to hold up petitioner lacks the only immunity.
The only immunity it's ever asserted. That's a wow. Yeah, that's wow. Dude. Yeah, that's wow.
Thomas is not tiptoeing. He's like, let's get there. Like
Thomas isn't interested in tiptoeing around this issue.
Nope.
Yeah. It's like, we're not going to decide if you have sovereign immunity. Well, clearly they don't. Thomas says. Because Puerto Rico
down the road.
Puerto Rico is clearly, for legal purposes, the same thing as the federal government of the United States. We've discussed this many different times, many different ways. The federal government has sovereign immunity. States have sovereign immunity. Puerto Rico is not a state. Okay? So Puerto Rico is not sovereign. All right? Puerto Rico is a territory of the United States. For legal purposes, it is the United States.
Oh, and Thomas starts throwing shade. You got to keep reading. He starts throwing shade.
The board moved to dismiss by invoking state sovereign immunity, which the board claimed to possess as an arm of Puerto Rico. They responded that Puerto Rico has no such immunity, and even if it did, the immunity would be abrogated. Bound by circuit precedent, Puerto Rico enjoys state sovereign immunity, but the board also agrees with the argument that immunity was abrogated. When the board asked us to review the holding, they once again raised as a lead argument, pointing out we could not logically reverse the First Circuit without addressing whether the board actually has immunity. And in its merit briefs, the people made Puerto Rico's lack of sovereign immunity its lead argument. There's nothing more they could have done to preserve this issue. So basically, they're like, hey, this was the very core of their legal issue. This was issue number one. They did everything possible to make this issue number one. And, that's what they wanted to fight about. Yet the majority skips it entirely, while assuming it. In doing so, effectively consigns the case to dustbin, remanding it back to the circuit, where circuit precedent will dictate outcome. They might forever be wondering whether we grant certiorari only insofar as our review would favor the board. Ooh.
Gosh, I'm telling you, this is like Scalia level shade. This is.
Ooh. The majority asserts it need not assert this argument because proceedings below did not examine it, and we agreed to tackle only the abrogation question. But it's unclear why the court would have examined the matter any further given its own precedent. Ooh. The fact that the First Circuit barely addressed the issue below, simply noting its own precedent, is surely irrelevant. We've often granted certiorari in questions that were resolved below with drive-by citations to binding precedent, sometimes in footnotes. Holy shit.
This is fantastic.
Holy shit. Holy shit. This issue is a predicate to making an intelligent resolution, as it makes no sense to analyze abrogation of sovereign immunity without first determining whether it's immunity. Because I think the court has a duty to pass upon issues that are fairly presented, preserved by parties and necessary to support. I would have considered the issue. From the start, the board has asserted that it possesses immunity under the 11th Amendment. The First Circuit agreed, saying that Puerto Rico is kind of like a state. But, the plain text of the 11th Amendment says something about states. And because they're a resident of Puerto Rico, I can only assume the board and First Circuit meant to refer to sovereign immunity that's inherent to 50 states. Holy shit. Holy shit, dude. As we've explained, inherent sovereign immunity reflects the inherent design of the Constitution. At the founding, states considered themselves fully sovereign nations, and part of their sovereignty was immune from suit. When advocating for ratification, leading Federalists assured the Constitution would not allow citizens to haul states into federal court, which, then was the Supreme Court did something different, which then led to the 11th Amendment because of exactly this reason. The court therefore held afterwards, and therefore the 11th Amendment was passed because of how pissed everyone was. Thus, in general, the Constitution does not allow federal or state courts to hear cases against states without their consent. Here, however, all sides agree that Puerto Rico is a territory, not a state.
The thing is, this is saying the quiet part out loud. It's saying the quiet part out loud. What if you want to remedy this? You can do that. There's a way to do it. You got to do it. You just can't keep saying, we're just not going to deal with this problem. We're just going to assume certain things. And the court's done that for so damn long on so many damn issues. Like even the majority opinion, you're reading it and going, oh, you just didn't want to do it. They come right out and they kind of say, nah, we're just going to kick it down the road a little bit further. It's an issue.
Justice Thomas has a really fair point, because for whatever reason, the Supreme Court has been really, really uncomfortable with Puerto Rico and their status for a very long time. They don't want to draw the necessary conclusion. They don't want to do it because they're really uncomfortable with it.
And what's funny is Congress isn't going to here. And it's like it's the chicken and the egg argument. Yeah. Congress isn't going to do anything until the Supreme Court makes the hard decision. Congress isn't going to fix it because they have no motivation to fix it, because Supreme Court's obviously just going to keep kicking the can down the road.
Yeah. I mean, from basic principles, This isn't complicated. They just don't want to draw the conclusion.
They don't.
The basic principle is easy. I mean, the federal government is sovereign, states are sovereign. Puerto Rico is neither of those things. Puerto Rico is not sovereign. It's a territory of the United States. That means it is the United States. That means that the United States is God when it comes to Puerto Rico, because it is the United States. They can do whatever they want. Kind of like DC for that matter, because it's the same idea. DC is also not sovereign. Congress can do whatever it wants. Congress passed a Home Rule Act, or DC did. Either way, it doesn't really matter. But either way, Congress can overrule it. Congress can just change its mind. Congress could pass a law tomorrow. Be like,
DC passes a
DC
budget
could pass the law.
Congress-
DC could pass a thing tomorrow. Federal government could pass a thing tomorrow. Be like, Home Rule Act. What's that? That's dumb.
Yeah,
they can do anything.
And I get this is why people get so animated about it when they live in these jurisdictions.
Yeah,
and that's why
you got 3 million people
changes to happen.
You got 3 million people who are citizens by statute, incidentally, not by the Constitution. So that makes a bit of a difference, because there's a statute that says that people born in Puerto Rico are citizens of the United States, which also incidentally means Congress could change its mind.
Yep, which is scary.
And say, hey, what if people born in Puerto Rico weren't citizens of the United States? They could do that because they're God. But for whatever reason, the Supreme Court is really, really uncomfortable with this conclusion, because it's like we have 3 million people living down there, which is more than many states, incidentally. And we are saying that they have no sovereignty, but that's the right conclusion. But they don't want to do it. But Justice Thomas is like, let's do it. Let's do it. Let's do it.
Well, because Thomas is like, I heard an argument, and honestly, it's one that kind of stuck with me for a long time. There are jurisdictions where you walk into court and there's opposing counsel who's been there for 30, 40 years, and they say, well, we've been doing things here this way this whole time, or for this long period of time. And I look back and say, just because you've been doing it this way for that long doesn't mean it was ever right.
Yeah. Yeah.
You're not making it any easier on yourself. Like, you're just going to make it worse.
And even in the insular cases, they weren't willing to really do it. Like they said, even in the insular cases 120 years ago, they said, okay, Puerto Rico isn't subject to the Constitution like all the other states, but this decision should only stand for a time. They weren't even willing 120 years ago to say, Puerto Rico, you don't get this benefit because you are a part of the United States. You don't get any protection. Even 120 years ago, they're like, well, you don't get protection for now, but someday. It
just makes it worse when the ultimate decision gets made. I've made comments on different controversial opinions that come out. And the issue is, it's not so much the opinion that I have an issue with. It's that the further you kick it down the road before reaching the conclusion that was the logical conclusion that needed to be made a long time ago.
Yeah.
You're just making every person that lives in the citizenry more emotionally involved in the overturning that, or in changing that law. Fix the problems. Congress, do your job. Supreme Court, remind Congress they have to do their damn job. Supreme Court, do your job. Everyone does their job and everything works. Son of a bitch. Sorry.
Or force Puerto Rico to make a choice, because that was a bill that was proposed that I covered on my channel. I assume it didn't go anywhere. I think it passed the House, incidentally, but it will never pass the Senate. Or maybe it's the other way around. But there was some act that would force Puerto Rico to be a choice. It's like independent country or state. You can't be a territory anymore. You have to pick one.
I mean, when Puerto Rico had their insolvency issues, Congress had to literally jump in because there wasn't a code. There wasn't a provision in the bankruptcy code that allowed them to restructure. So Congress had to be like, oh crap. Gotta do something. Let's just copy and paste. Let's take BAP-CIPA and take the bankruptcy code and we're just gonna copy this section, this section, this section. Oversight board, sure.
Everything is a patch to the fundamental problem. Everything's a patch to the fundamental problem.
Yep. But on that note,
just have the balls. Just have the balls to be like, Puerto Rico, you are nothing. You are a slave to the United States. Just have the balls to do it. And then, the citizens of Puerto Rico will probably be a little bit pissed about that. And maybe that will cause them to do something.
Well, and that's the point. You have to say the offensive thing that people have just stopped saying, so that Congress goes and actually does the job of fixing the thing.
Yeah. Yeah. While we're at it, keep kicking that Indian tribe issue down the road.
Let's not resolve that one. I mean, Gorsuch tried the end of last term, the end of the term before.
Yeah.
I mean, you start to see some of these corrective actions taken, but then it's like 2 steps forward, 1 step back.
It's because Congress, you don't have any balls.
Every time, 2 steps.
All you have to do is pass a statute saying the Indian tribes don't get to be tribes anymore. You don't have any balls. You got stuck. You keep coming to us to fix your problem because you don't have the balls to pass a statute that says Indian tribes. What Indian tribes? They don't exist anymore at all. You don't have the balls to do it, so you keep coming to us to fix your problems.
And it's reconciling. There is an entire body of law that's reconciling treaties that are, you could teach a 3-year law school, like 3 entire law school years, focused on those cases.
Yeah. Oh no, for sure. But like the thing is, at least as far as I'm concerned, like the United States has a sovereign right to withdraw from any treaty, period. Because like any treaty with any country, treaties are a matter of sovereign agreement to reconcile things. And also for that matter, the United States gets to recognize and de-recognize countries as a matter of its sovereignty. Because the United States gets to choose what are countries. The United States disagrees with other people in the world about what countries are. We don't recognize certain places in the world because we get to make that choice. So there is nothing legally that precludes the United States from saying Indian tribes, what Indian tribes? We don't recognize you. You unhappy about it? Go to war with us. That's not how it works out.
The fallback and I mean, essentially it would be annexing property that they promised to other people. That's the thing. It's feasible. It's within their power.
Well, the people individually is one thing to the extent they have like land. That's one thing, but to the tribe itself as an entity, lol.
This is also someone my parents, grandparents grew up in Arizona. The tribal debates and those disagreements, they run deep, and I understand a lot of the different sides to all those different arguments. Those cases are remarkably emotional.
I understand this. I'm not telling anyone what they should do. I'm just a legal analysis, right? I don't do policy. I'm just telling you what's possible.
You're right.
I'm just telling you what's possible. I'm a legal analysis. I'm like, okay, here are the logical legal conclusions. And like those conclusions are really uncomfortable. Like, what do you want from me? That's what someone wrote in the Constitution. I'm just telling you what it says.
Mm-hmm. It's kicking the can down the road. It's just a mess. It's a mess.
I think sometimes people confuse my statements about what is from what should be. Like, I'm not here to tell you what should be. I'm not here to tell you what's good.
No, I don't confuse those. I know what the analysis is, and I always appreciate it. Especially, my mind tracks with Thomas's dissent there.
Thomas is right. Thomas is 100%
I think he's right.
He's 100% right. There's no ambiguity. He's 100% right. You got 8 members of the Supreme Court who don't want to do it because they don't balls. But Thomas, well, something you can never confuse Thomas for is not having balls. He has balls. He's always had balls. He has balls when it comes to everything. He was always wanting to go further than Scalia because every single time there's an incorporation case, every single time he writes a concurrence because he's like, I don't believe in the entire concept. I don't believe in the entire concept of substantive due process. It's dumb. Substantive due process is dumb. We should do privileges or immunities right instead. And he's right.
For numbers and emanations.
Yeah. Every time Thomas writes a thing, it's like, yes, the entire concept of substantive due process is dumb. He wrote it in the Dobbs decision too, which made everyone really, really happy too. Because as the Supreme Court's overturning abortion, and they're like, well, there's these other cases like, Griswold and stuff, but we're not saying anything about it. Thomas over here, straight to the rescue, is like, yes, I don't believe in any of this stuff because it's all rooted in substantive due process. Let's overturn Griswold and let's overturn all this other stuff too. Let's overturn it all. It's all stupid. He is not afraid to go to the end of the page, man.
He's not. There are some personalities on this court that are there are some strong personalities on this court. Then there's some weak ones, Roberts.
Just as a friendly reminder, by the way, as long as we're talking about statutory citizenship and being uncomfortable with Puerto Rico, just a friendly reminder that Indians are also in the same exact position. Native Americans didn't have citizenship until Congress granted it by statute.
Which is scary. I mean, that's the
so
thing.
Again, hey, Congress, hey, you know what? All these Native Americans who are born in the United States, well, you know, if let's go all the way, let's go to the other extreme. Let's say that they're not citizens of the United States at all, even though they were born within the boundaries of the United States because they're part of these domestic nations. So they're not citizens of the United States. That was the law until like 1923. Okay, so let's go hardcore the other way. How about they're not citizens of the United States at all? Go.
It is the stark contrast and the uncomfortable debates that occur around this. And you're right. The discussion has to happen, and people have lost the ability to have the actual discussion without becoming overwhelmed in drawing to the conclusion and how terrible the conclusion is. But conclusion is a conclusion. You can't just ignore it sometimes.
No, everyone prefers the uncertainty rather than the conflict, because, you know, if the Supreme Court were to really have balls, it would force the conflict.
There it is again. Balls.
Because the Supreme Court could really have balls and be like, yes, the Congress of the United States can do whatever it wants with respect to the Indian tribes. How about no Indian tribes? How about they have sovereignty? How about their people are citizens? How about not? Hey, Puerto Rico, they can do whatever they want. Do they have citizenship or not? How about no? How about yes? How about we force them into being an independent country? We'll do an Indonesia, and we'll force them into being an independent sovereign despite their will. That'd be good. Which we could do. Which we can do. Is that Philippines rather than Indonesia? Damn it. Shit.
It was Philippines, right? Yeah.
Was it Philippines, not Indonesia? Fuck.
I can't remember.
I was trying to be so clever.
But you were right. I think you're like
It's one of them.
We did. It happened. Just somewhere you're like, nah, not. You can go ahead and be your own country. We're gonna leave you.
Yeah, we'll force them into it. That'd be good. Yeah.
So.
Yeah, no, like the 3/5 thing. The 3/5 things is kind of actually a good case on point, because by actually sticking to the 3/5 things, well, it kind of forced the issue. The way it forced the issue was with the death of 600,000 Americans. But, you know, hey, it brought it to a head. And then we came up with the 14th Amendment and said, hey, maybe the 3/5 thing was a bad idea.
Just a thought. Maybe we should actually pass the amendment that makes the thing fixed, the thing that we screwed up the first time.
Could you imagine that actually, to some extent, the Supreme Court did try to dick around the issue.
They did.
If you're trying to like
conflict,
if you're like looking at cases like the Fugitive Slave Act case, and you're dealing with
played with the property rights. They messed with it. They kicked the can down the road. They wouldn't. The
Supreme Court
to the heart of the
like
issue.
A lot of those decisions that people are really hostile for now, that the Supreme Court did, a lot of them were trying to avoid the issue, because the Supreme Court's like, we can't do this, because if we do, it's going to cause a problem. So a lot of those cases were the Supreme Court trying to do exactly this, trying to avoid the issue. And of course it didn't work ultimately, but they tried. And so here's a good question. Was the Supreme Court right to try to avoid the issue on slavery? Were they right? Because, well, Civil War.
I mean,
were they right to try to avoid the issue? Are they right to try to avoid the Indian issue? Are they right to try to avoid Puerto Rico? It probably wouldn't end in Civil War the second time around, but it wouldn't be great either. So are they right to try to avoid the issue because the consequences are just so high?
And the longer they avoid the issue, the more emotionality seeps into the public discourse, the harder it is to address the issue. The longer you ignore these things, the harder it is to address them. And when you do eventually address them, the more dug in on their positions both sides are, and the more that Congress and Congress people, being elected representatives, are out there inflaming the people rather than actually coming to the table to work on the issue. So,
yeah, uncomfortable things.
It is. All right, buddy. I got to bounce.
Oh, I was having so much fun though.
I know. I was glad I was able to join. Honestly, it was.
Thank you for joining. You really made my day.
That was good. I'm glad. That was great. I loved.
Before you leave, why don't you give everyone a plug for your channel? Tell us what's upcoming on your channel and stuff.
Law and Lumber. So we brought back Trials of the Century as a members only pre-show last night, where we were essentially doing members only, so you guys could watch how the show gets created between Ian and I. The actual live Trials of the Century is coming up next Wednesday. It's going to be returning with a discussion of what makes a trial one of these trials of the century, and whether a certain trial that ended this time last year could possibly be considered that. And then we have Friday Night Frenzy coming up, where we're going to do a breakdown of, whatever's happened this week. I'm sure that some of the things that Kurt's talked about will be mentioned. We shall see. But thank you guys. I love being here. It was awesome.
All right. Well, thanks as always for our friend Law and Lumber. Make sure to check out his channel. Rob, thanks for standing by. You really made my day. And I hope you have a fantastic rest of the day.
Thank you, buddy. You too. Bye.
All right. Bye-bye. Billy signs off. All right, cool. Yeah, that was Rob from Law and Lumber. I appreciate it. In response to this question from Hen Solo, thank you for the generous super chat. Guam and American Samoa and other territories would like to be citizens by statute. They aren't citizens right now. Just America Samoa, for some reason. Citizens of Guam are citizens of the United States, but not in America Samoa, for some reason. It's been suggested, although I don't know the extent to which this is true, it has been suggested that the reason that people are not citizens of American Samoa is because American Samoa is concerned that they have a male-dominated government. They have a patriarchal government, and they're concerned that if they were citizens of the United States, then like all these laws, like Title VII, for example, would apply, and it would prevent American Samoa from being a patriarchal government. So I don't know to the extent to which that's true, but that has been the best rationale I've heard, that American Samoa doesn't want them to be citizens because it would lead to uncomfortable implications with the nature of their government. So American Samoans are U.S. nationals, not U.S. citizens. So, yeah. That is my best understanding of the thing. All right. That was so much fun. Can I explain national versus citizen? The easiest way to explain it is it's basically they have a green card. That's the easiest way to explain it. People who are born in American Samoa have a green card. They're lawful permanent residents, not citizens. That's the easiest way to explain it. Yeah. Oh, yeah, we still have two more. Oh, we still have one more decision. We can do that now. You sent me a DM on Discord with gifted memberships? Oh, thanks. Let's take a look. Sandra sent me a DM. Gifted memberships today. Alan Parker gave gifted memberships. Thank you as always. Jessica 10 Hag gave 10. Sandra Ramirez gave 50. That's very, very generous, Sandra. Thank you very much for those gifted memberships. We had super chats today from 10 Solo Rich and one other super sticker. That's very, very generous. Thank you very, very much for all those as well. I appreciate all you people who help to support the channel. You help to fund things like the art that I do. That costs money. I do audio processing on the edited videos. That costs money. I do this streaming service costs some money. And there are a couple other things that I do for the channel that also cost money. So by helping. It also allows me to eat. I like the eating, I have to say. Even though, we have the Gumbo Sans Roux debate, you guys help me eat. So thanks with the eating. That's nice. Appreciate it. Someone sent me a thing about ATF, United States District Court in Virginia. Some people suing the ATF. Motion to dismiss. The motion to dismiss is denied. A motion for summary judgment of plaintiff is granted. So take a quick look at this in terms of this decision. Okay, so they're 18. Between 18 and 21, they want to buy a handgun. They couldn't buy a handgun because they're not 21. Blah, 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 blah. They have a right to purchase handguns constitutionally despite not being 21. Blah, blah, blah. They don't have standing. I think they have standing. They say there's a third party standing problem. Oh, they say they don't have standing because despite the fact they can't purchase a handgun, they can acquire one from a gift from a parent. That's stupid. Oh yeah, you don't have standing because you can't buy them, but you can be gifted them, so it's totally fine. That's a dumb argument, ATF. Thanks for trying though. So yeah, you have standing. Yeah. Second Amendment, Bruin, historical. Of course, the Militia Act of 1794, or whatever it is, says that the 17-year-olds must possess guns, which is still good law, incidentally. It's still in the books. And the 17 to 45-year-olds are part of the militia of the United States. It's still in the books. No means and scrutiny, blah, blah, blah. Plaintiff should possess firearms under the Second Amendment, including Glock pistols, blah, blah, blah. Blah, 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 blah. The Fourth Circuit has not ruled on this question. The people who are 18-year-old fall within the people of the United States, which seems pretty clear. If they're the people for other purposes of the Constitution, I think they'd be the people for the purposes of the Second Amendment, so that seems pretty clear. Political community, yes, we know that deals with what case does that language come from? It's probably cited in here somewhere. Yeah, United States versus Verdugo Eucrates. I can never remember the name of the case, but when I see it, I recognize it immediately. So who's part of the political community? Basically citizens and green card holders at least. Beyond that, we're not quite sure, but other people maybe. Blah, blah, blah. Etc. So forth, blah, blah, blah. Early days of the Republic. 18, 20-year-olds are members of the political community, at least since the passage of the 26th Amendment. I would think so. Continuing on. Prohibitions to purchase are not supported by history. Again, and then they cite the Militia Act, which is from, they say what year it is. 1790 something. 1789. No, that's not right. 1785, 1787. Oh, they're talking about state law at this point. 1792. That was the magic year I was looking for. 1792. Every free, able-bodied white male citizen of 18 to 45. I thought it was 17 to 45. This says 18 to 45. Okay, maybe I was off by a year. Or they amended it at some point. Blah, blah, blah. Da, 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 da. It's nice to know that being a 42-year-old, I'm still part of the militia. I've got that going for me. That's nice. Blah, blah, blah. Historical restrictions on 18 to 20-year-olds. You're not going to really find them. Conclusion, therefore, the 18-year-olds can buy handguns, says the district court. Yeah, that sounds about right. Okay, great. There's no gumbo without roux. There is in my world. Lol. So, yeah. That sounds about right. All right. We're not done with the stream. Does people leave? Someone sent me a thing about this and I read it in real time. Please didn't leave. Please don't leave. If you leave me now, you take away the very best part of me. Ooh, chat, please don't go. Dun, dun. Yeah, so it says 17 now. Okay, so they amended it at some point. Okay. Want you to stay. All right, great. Let's do another case. Let's do this one more Supreme Court case, and then we'll probably wrap up with Florida Man because we've been here for almost 3 hours now. All right, yeah. All right, so let's read some more. All right, so let's see. Let's just read this case. All right, so for today's story, we discussed the Supreme Court case of Percoco versus United States from the Court of Appeals for the Second Circuit. Let's go ahead and understand this new law that is developing. The petitioner, Mr. Percoco, served as the executive deputy secretary to New York governor from 2001 to 2016, a position that gave him wide-ranging influence over the state. During an 8-month period in 2014, Percoco resigned from government service to manage the government's re-election campaign. During the hiatus, he accepted payments totaling $35,000 to assist a real estate development company owned by Mr. Aeo in dealings with the Empire State Division, a state agency. So he is the executive deputy secretary. During an 8-month hiatus, he's working on the campaign. He receives money from a real estate company to help him with a state agency. So, okay, we might have some problems there as it relates to that. After Percoco urged a senior official at the state to drop a requirement that the company enter into a labor peace agreement with the local union as a precondition to receiving state money for a project, the state informed the individual the following day the agreement was not necessary. So one of the things the state appears to typically require to get state money for these projects is an agreement with unions that, they play nice with each other. The state wants to spend money on places that have union affiliation. So this guy wanted to enter into an agreement. They said, please do the union thing. He said, could you make them not do the union thing? And so the state said, okay, fine, we won't make you do the union thing. When these dealings came to the attention of the U.S. Department of Justice, he was indicted and charged with, among other things, conspiracy to commit honest services fraud in relation to the labor peace agreement. So we are concerned about honest services fraud because of this agreement with the private entity to get this contract from the government. Throughout proceedings, Percoco argued unsuccessfully that a private citizen cannot commit or conspire to commit honest services fraud based on his own duty of honest services to the public. So, honest services fraud would be that you owe a service, but in this particular role, he didn't owe a service, he says. All right, he's not part of the government because he had resigned. So he was not part of the government to which this honest services was owed. He's just a private citizen at this point. And so he says, okay, I can't commit honest services fraud because I don't own a duty. And also the business doesn't own a duty. So they can't commit honest services fraud. Over objection, the trial court instructed the jury that Percoco could be found to have a duty to provide honest services to the public during a time he was not serving as a public official if the jury concluded that he dominated and controlled any governmental business and people working in the government actually relied on him because of the special relationship she had with the government. So the trial said, okay, look, you might be not working for the government in a formal legal sense, but this is only a temporary thing. You worked for the government before. Everyone knows you're going to work for the government again. So you are technically at this moment a private citizen, but everyone understands what's really going on here. So we're not that dumb. So if the jury concludes that you're really in control of the business and people rely on him because of the special relationship, then it's really honest services fraud because you're not really working as a private citizen. That was the idea. As relevant here, the jury convicted Percoco on the conviction relating to honest services fraud. On appeal, the Second Circuit affirmed, explaining the jury instruction fit the Second Circuit's understanding of honest services fraud adopted by the United States courts earlier. So we think that this is honest services fraud. So is it honest services fraud or not? The United States Supreme Court rules instructing the jury based on the Second Circuit's decision in a different case relating to the legal standard for firing a private citizen owes the government was error. So as a private citizen, the standard was a mistake. So he doesn't owe honest services fraud. Prior to the 1987 decision, all courts of appeal had embraced the view that federal wire fraud and mail fraud statutes prescribe what came to be known as honest services fraud. Most cases prescribed under these statutes involve a public official accepting a bribe or kickback that did not necessarily result in a financial loss for the government employer, but did deprive the right of services. So the nature of the fraud was in receiving the bribe. And the relevant cases showed that it wasn't necessary to prove the government lost out, right? That wasn't necessary to prove. The receiving the kickback itself was enough because now you had divided loyalties, right? You're accepting money from two masters. You are a government employee, and in addition to this, receiving a bribe. So even if you could prove the government is no worse off, that isn't enough. The nature of the fraud is you accepting the money because of your divided loyalties. So that is enough under the relevant law. The Second Circuit had considered a different fact pattern in a different case, in which the government had charged an unelected individual with honest services fraud for using his position as a political party chair to exert control. So now you're not a public official, you're a private official, in this case, head of a party, and try to use that influence to the government. So you, the political party chair, are guilty of honest services fraud. The court held a private person could commit fraud in this domain if they dominated the government. So your nature of your relationship is such that it is sort of as if you were a government employee, kind of. Shortly after this case, however, the court rejected the entire concept of honest services fraud in a different case. But Congress had responded swiftly and enacted a law which provides that a scheme or artifice to defraud includes a scheme to defraud of honest services. So we sort of discussed this earlier, right, in a different case, right? We were talking about these intangible things. The wire fraud statute says it is fraud to deprive someone of property, okay? Your honest services are not property in this sense, right? They're not a tangible thing or something other that you could alienate from. So honest services do not fit within the definition of wire fraud. But Congress said, yes, it does. We're going to pass a specific statute that deals exactly with this issue because we think it's really bad. Okay? So Congress responded to something not being illegal by making it illegal. Rather than cramming it into an existing statute, let's create a new statute. Okay? So Congress did a thing. It's like the Supreme Court says wire services only apply to tangible property or things that can be alienated. And honest services is not one of those things. So Congress said, fine, no problem. We'll create a statute that specifically says it's illegal. So great, Congress did a thing, all right? So decades later, this court rejected a broad argument. The relevant law is unconstitutionally vague and clarified the right of honest services can respond to kickbacks. So someone said, okay, this law is too broad, and Supreme Court said, no, that's dumb. It does include fraudulent schemes to deprive someone of honest services through bribes or kickbacks. So no, it is not so broad, we can't figure it out, okay? You owe a duty of loyalty to your employer, in this case, the government. You're accepting bribes or kickbacks, that's bad. Don't do that. All right? So the relevant history informs this court's decision. The relevant law in the Second Circuit concluded that Congress effectively reinstated the theory of honest services fraud by adopting the language. So previously, the court said, no, not so much with honest services fraud. Congress says, yes, honest services fraud. But we took care to avoid giving an indeterminate breadth that would sweep in any conception of intangible honest services. So what Congress wrote is what Congress wrote, and we're not sweeping in everything. We're sweeping in what Congress wrote. By rejecting the government's argument that this should apply to cases involved undisclosed self-dealing by a public official or private employee, the relevant court made clear that the intangible right of honest services must be defined with clarity typical of a criminal statute. You have to know what's illegal, and should not be held to reach an ill-defined category of circumstances simply because of a few decisions. So, unsurprisingly, when Congress passes a law that makes something criminal, it has to be clear. To avoid making it so unclear as to be, a problem, we had to define it. And so it doesn't include some things that used to be illegal because Congress, when they wrote the law, only made certain things illegal. So they only defined certain things to be illegal. So old case law that said, hey, some things are honest services fraud, and we said honest services fraud as an entire category is not illegal. When Congress made some of it illegal again, they didn't sweep in everything. They only swept in the stuff. Congress made a choice, and they defined a statute. So let's do that. The relevant arguments challenging the honest services conspiracy count at a time when he was out of public office sweep too broadly. The court rejects the idea that a person nominally outside public employment can never have a duty to the public. So we're not going to go quite that far, all right? So his argument that a private citizen cannot be convicted of private services is too broad. Okay, we're not going to go that far. Private citizens may have a duty to the public in some circumstances. Through a principle such as agency, for example, an employee, a person who's not a formal employee may be an actual agent. So we're going to solve this problem, at least in part, by turning to concepts like agency law, all right? Which is how we deal with this, for example, for Fourth Amendment purposes, right? The police want to search a home. They can't do it themselves for whatever reason. They hire a private investigator, all right? The private investigator is now a police officer. He is an agent of the police, okay? You hired a guy to do a job you can't do yourself. He's an agent. He's now subject to the Fourth Amendment, just the same as you are, okay? So if a public agency hires someone, like, for example, a contractor maybe, or whatever, that is an agent, well, that private person owes a duty to the employer in the same way as if they're a government employee. So you can't get around this by being a contractor or other kind of agent. If you're hired to do a job by the government, well, you still owe them a duty, despite the fact you're a private employer, because that makes sense. Okay? The court therefore rejects the absolute rule that all private persons are not subject to this, because if you're an agent, for example, a contractor, you owe a duty. But in this particular case, that was not proper. The instruction implied that a public has a right to a private person's honest services when a person's clout exceeds some ill-defined threshold. So in this particular situation, he's not an employee, he's not a contractor, he's not an agent. He's just someone who might have some influence on the government. Without constraint, then, the government's instructions did not define this intangible right with sufficient definiteness, because we don't know when it's illegal. Because private persons obviously might be able to influence the government. You hope every private person has a right to petition the government for redress, for example. So a private person might be able to affect change on the government, depending on the nature of their petition. An individual can make a difference. So how do you know when it's that a person has too much influence? How do you know? And the court's like, there's no way to define it. The government does not defend the jury instructions as an accurate statement of law, but insists imprecision is harmless. So it's harmless error. And no, that's kind of harmful, right? If we don't know when too much is enough in a way that helps us figure this out, the law becomes vague. The government argues a private person owes a duty when the work has been selected for the government in the future, when a person exercises the function of government with acquiescence. These theories, however, differ substantially from the instructions given the jury. So the government says, well, maybe this is the right legal standard. And the Supreme Court says, well, that's not what you told the jury. So either way, it doesn't matter. And therefore reversed. Alito files an opinion in which the Supreme Court is unanimous. So that brings us to the end of this case of Percoco versus United States. Percoco was in a highly influential position with the government, but during a relevant period, he resigned in order to help the government's re-election campaign. He'd gained the position again, but he's a private employee. And during this period, he took some money to potentially influence the government, which might itself be legal, by the way, depending on exactly what's happened, because maybe he's just a lobbyist now, right? Depending on the details. So he took money, potentially, to lobby the government, which might be completely legal, totally legal, depending on the details. So as a private person, he asked them to drop this requirement, and they did. And, his friend was able to get a lucrative project, which is nice. The government charged him with a whole bunch of stuff, including, notably, honest services fraud. So it might be illegal for other reasons, maybe not. But whatever can be said, it is not honest services fraud because he is not a government employee, he is not a contractor, he's not a formal agent. He's just simply someone who has some sort of nebulous influence, which is insufficient to gain legal liability under this legal theory. So not so much with that particular charge, whatever might be said of other charges. And that brings us to the end of discussion of this case. Carrie says, you love that I read it. I quit listening because it's legal speak and then I say so. Yes, I do try to explain it. I try. And I try to do a good job as a teacher. And sometimes I forget, of course, what other people don't necessarily know. But I try very hard to explain and sometimes over-explain and try to explain what's going on and the details. So I really appreciate comments like that, Kara, because I try really hard to make it understandable and explain and show you why certain things are true. It's like by reason and by analogy and by using examples that might be a little bit more understandable. Try to translate it to examples that might be more approachable. So I really do try, and I appreciate that you noticed that. It's very, very kind, guys. I'm very, very kind. And sometimes I don't always do great, but I try. One more gift from Jules Buddha. Thank you, Jules, for the gift. I appreciate it. I'm very warm all of a sudden. I hope that doesn't mean anything, but I'm just very warm very suddenly. I'm going to change into a t-shirt, change into a moisture wicking t-shirt, change down clothing because I'm a little warm here in a second. Just 2 super chats today, Law and Lumber and the Solo Chicken, which we read. And thanks to everyone who it is not raining in Austin right now. Temperature 78 degrees, 78. I feel a little warm. I'm going to go get some zinc too while I'm out because I think I'm coming down with something and I like to take zinc when I'm sick. It seems to help. So I need to get some zinc. Anyways, yeah. Okay. I'm signing off for now. Stories are getting posted, by the way, already. My short, I already have videos scheduled for 1, 4, and 7. The video at 1 o'clock will be dealing with George Santos, of course, for timeliness reasons. I have set the shorts to go out at 12, 3, and 5. It sometimes takes a little while to get re-uploaded. So hopefully those are on TikTok now and will be soon sent other places. I could use some water too. I definitely could chug some water for sure. Yeah, good call. I need to chug some water hardcore. Good call. I need to chug some serious water. Good call. So I'm going to chug some serious water and sign off. I've been Uncivil Law. I hope all's well. Cheers, my friends, and goodbye.